It was dismissed. Hearing, please wait for some time. Let me dispose of some hearing matter. No use. So, Lady, please see how many matters are there. There are more than 200. Let me dispose of some of them. Let me dispose
of the process. I allowed the first day, you are not come on the first day, second day, you are valid.
all right.
The files now.
One sleep. Only one matter. They can yes, colony. One 35 and 137. What do you want? So what do you want, madam? Yes, it's appearing in the hearing list. Urgent upgradation, it's not possible. If you want, I can release it. Urgency, I appreciate your urgency. I can release this matter if you have urgency. Inclusion first day I have allowed, it not mentioned. But upon notice, have you served notice upon the other side? So have you given a notice that you will be mentioning this matter today?
I need 3 weeks time to file the opposition.
3 weeks time to file the opposition. Alright, let it be listed to make your opposition. What directions? Alright, it has to be mentioned. You mentioned it for directions. Yes, call the list. Item number 3 is that municipality matters. Witness state. Yes, Mr. Basu, you are for the petitioner. What happened? What happened after that? Mr. Nayak has not come today. He is appearing for Bonga. And who is for Rayganj? Yes, who is appearing for the state? You are for the state. You are for? Madam, you are for? State. Come in front, come in front.
It can be done.
In respect of one means which municipality? Or petitioner number 1?
No.
The petitioner is 1. Yes.
But it is not maintainable.
Not maintainable. Why? Money claim.
Money claim.
Money claim, all right.
And the Article 12 perhaps with due respect, perhaps not properly descent, parties have been paid in a fashion that.
So, Samantu, you said for 1 it can be done. What is for 1? What is for 1? Oh, for petitioner number 1.
No.
Oh, for one of the municipality. Mr. Basu says he has deposited the court fees for. Yes. You have complied with. Mr. Shamanti, there is no dispute by withholding this.
Now,
Show me that what is the dispute.
yes. Please. In respect of Seniority, it can be done.
In respect of Hoshirat, it can be done.
Okay.
How soon it can be done? What is the amount due? Tabula form, Mr. Basu, stage 10. Hoshirat is item number 1. So, what is the amount due?
In respect of serial number 3 only.
Serial number 3 is Balurghat. The Balurghat, what is the amount?
The amount is 623,175.
623,175. All right. How soon it can be done? Why? Why 6 weeks? The order was passed on September 17th. So 6 weeks you have got.
Why not the claim made? The claim was right. That's the date.
Yes. How soon can you make this payment? 6 lakhs. If the state wants 6 weeks time to pay 6 lakhs, difficult thing.
I have evidence even subject.
That is why
Cannot be 6 lakhs.
6.
I can say. I'm not giving any network. I will get to that will not see.
Yes. So, and that is with regard to Balurghat. So Balurghat. So what is?
They will not pay anything here.
So they will only give the that. Yes. So as soon as the requisition or the no objection comes, you can pay that. So for this no objection, or what is the no objection? No objection by Friday. No objection. Why? Too early. This week starts. Start with this week. Thereafter next week. Some other things.
Last year, before
Yes. Clause 18 of the terms. Page. Thursday. Why? No. Only Friday is holiday. Then do it by Wednesday. Only a no objection by email it can be done. By email it can be done. Page. Report of the municipality. Yes. Report is deponent is Sajal Kumar Sarkar. Balurghat municipality. Account file.
Now it says the payment is successful period by the chairman not. This is from all the division of municipal are direct.
Where is that?
And
Chirodip. Because 18 payments will be made successfully by the chairman only on receipt of written recommendation from the executive engineer.
That means the executive change and execution. Eighteen and all that is a municipal unit value. Giving for all.
Uh, uh, Mr. Samanto Lanet advocate appealing for the state subjects that insofar as the claim of the petitioner against Balurghat municipality is concerned, the executive engineer he has received instructions from the concerned authority that the executive engineer shall issue the written recommendation to the chairman Balurghat municipality for release of the amount due and payable to the petitioner in respect of the works mentioned in paragraph 8 of the writ petition. Paragraph 8, clause 3 of the writ petition. First up, Mr. Samanto submits such recommendations shall be issued within a week from date. First up, in view of the submission made by Mr. Samanto, the executive engineer being the executive engineer in which circle? Respondent number 6 or respondent number there is the chief engineer. So chief engineer will issue this
In view of the submission made by Mr. Samanto,
the executive engineer, the chief engineer, municipal engineering department, being the second respondent, is directed to issue the recommendation, to issue the necessary recommendation to the chairman Balurghat municipality for release of the amount due and payable to the petitioner in respect of the item of work mentioned under serial number 3 at paragraph 8 of the writ petition. First up, on or before November 11, 2024. First up, Mr. Nayak Lanet advocate appealing for the Balurghat municipal submits that immediately after receipt of such recommendation, the Balurghat municipality shall দেখবেন আগেরটা যেটা রেকমেন্ডেশনটা যেটা বলেছি না সেটা যদি রিটেন না বলে থাকে রিটেন লিখে কি বললাম
Lanet advocate appealing for the Balurghat municipality submit that immediately after receipt of such written
immediately after and upon receipt of such written recommendation, the chairman Balurghat municipality shall release the payment, shall release the amount due and payable to the writ petitioner. First up, the chairman Balurghat municipality being the seventh respondent is directed to release the amount due and payable to the petitioner within a period of in the period of 2 weeks from the receipt of uh, the said recommendation from the chief engineer. Uh, yes, so now Balurghat is over. Yes. Acha, এটা ইয়ে দিতে হবে। Because you are the authority, you have to say. So you have taken instructions. I have said upon for instructions from the executive engineer. After taking instructions. Submits বলে
Mr. Samant submits na এটা বলে। In Mr. Samant submits, such recommendations shall be made in
না তার আগের লাইনটা
Mr. Samant appearing for the state submits
Yeah.
that in so far as the claim of the petitioner against Jalunga municipality is concerned, he has received instruction.
Yes, Mr. Samant have said he has received instruction. Mr. Samant, I started by saying that. You are saying no.
I have not said that. Saying that it's the mind.
Upon instructions from your client.
Now let us come to Petitioner.
Now is, yes. Mr. Samanto, what do you have with regard to Koshira? Now let us-
Go beyond the record.
Yes.
The record cannot, affidavit say about this advocate only raw what.
Yes, what is your objection with regard to Koshira? No, let us proceed one by one. Koshira, page 10 of, yes, page 10 of writ petition, yes.
Paragraph 8, they are about one figure.
Yes,
Total amount on the ground of trial,
yes,
what happened, not or trial run, executor conducted trial run from you. What are the river is equal? The rivers are not, there is no equal.
so what is the fault of the petitioner? What is the fault of the petitioner? You supply the water, you then how can you control the amount? Mr. Samanto, what is the fault of the petitioner?
What of mine to find it? Putting function to myself, but what of mine? I cannot run it. I cannot have it.
Where have you said that? That you cannot provide the water.
Total value of state contact is suggested. Out of that payment was.
Where from you are, where from the report of the state? Sanjeev Kumar, yes.
Some paragraph 7.
Yes.
And small amount, paragraph. Total value of the state contact.
No, paragraph 7 is say that however the environments.
No, it stated that after completion of the work within 300 days.
No, it's affirmed by Sanjeev Kumar. Sanjeev Kumar is, oh, I am looking at Bonga municipality. Sorry. So Sanjeev Kumar has affirmed 2 affidavits.
From the top, I'm reading from my.
No, let me find out that. Koshirat, yes.
Come to page 5, paragraph 7.
Page 5. Paragraph 7, yes. Yes,
Total value of state.
yes.
Total value of state contract is suggested, and out of that payment were made till date suggested. So therefore, payment afford on amount of non-provisioning as raw water not available. So that it is for made before the PA authority and even then it for supply as raw water amount has been estimated.
How could you release the part payment? How could you release the part payment? Without the trial run, how could you release the part payment?
Without the trial, it cannot be done.
Since you have,
Without the trial, what will happen is
deals, what will be there, but we cannot do anything without trial run. Trial run has not the situation that we have not intentionally committed the
They are not at fault. They have done their work. They are entitled to the amount.
So, what are the
without water, that is not the case that we have intentionally stopped this trial run. The thing is that without having no water in the river, we cannot run it.
Where is that agreement with regard to that water for trial run? Show me that. Is there anything, Mr. Basu, any condition with regard to this? Yes. Paragraph 7. Yes. After completion of works within 690 days and 3 months trial run and 5 years. Yes.
Without the trial run, it can not run. They don't start it there.
What is there for?
We are coming with the increment budget of must be mitigated in respect of one flood in resolved. In respect of one, the social amount it will be resolved. In respect of other two flood, we
It is not, you are not doing charity.
no.
One you have resolved, it's not charity you are doing to them. They were entitled to, you are illegally withholding that for nothing.
If I do not get this service, not the kindly.
They have done their entire job. Where is their fault?
They have followed the scope.
Whose responsibility is to supply water?
Nature, the gods.
Yes.
That is the agreement. Perhaps I have, but then the post medical they are not.
Show me that.
I have to learn. That is not difficult. But may I come back with that? Okay, you give me some time, I will come back with that.
Supply water. That is the
Which paragraph of the order? With regard to the trial run? Yes, yes. 17th September.
Yes.
As raw water was not available on a period, how soon the raw water can be supplied for functioning of the water treatment plant? Yes. What is your instruction?
Never. According to Mr. Samantha, never. I cannot supply. I have to fetch it from the river.
It is your headache.
Yeah, my headache.
I will purchase AC and there is no electricity. He will play why I am running, so you should not pay. Very good.
Elementary, it will not suffer.
Exactly, elementary.
With respect to my senior friend, it's irrelevant.
So that is the only objection.
With respect of both other two, that is all.
The insofar as the claim of the writ petitioner with regard to the Boshirhat municipality and Bonga municipality is concerned, the only objection of the state for issuing the recommendation for payment of the amount due to the petitioner in respect of the works done by the petitioner as specifically stated under clause 1 and 2 of paragraph 8 of the writ petition. Mr. Shamanto submits that since the trial run could not be submits that since the trial run could not be commissioned, the recommendation could not be issued for payment of the amounts. This is Mr. Basu, page 5, paragraph 7 of Bushirat and Bonga. It's the same objection. Yes, which paragraph states this? 6. Yes. In the report of the state, it appears that the specific stand of the state is that the payment has been withheld on account of non-commissioning as the raw water was not available. Stop. In the said report, raw water was not available for the trial run. Stop. No, this is, oh, sorry, this is the municipality. No, state, what is the stand of the state? State, there is no affidavit. Alright.
In the report of the state, it has-
In the report of the state now, the submission টা বলছে Mr. Samanto মানে সেটা বলুন একবার কি?
Mr.
So far as the-
Mr. Samanto submits that since the trial run could not be commissioned,
Mr. Samanto on instruction submits. Mr. Samanto, comma, on instruction, comma, submits.
Corroborated the report.
বলুন, on
that since the trial run could not be commissioned, comma, the recommendation could not be issued for payment of the amount. That's all.
তারপরে কি বলেছে?
The government is, it in the report of the state.
না, the report of the state না, কি ওটা কেটে দিন। The Bonga municipality and the Bushirat municipality have filed separate affidavits. Stop. It is evident from the said affidavit or report, have filed affidavits that filed reports in the form of in the said affidavit. Yes.
In the state,
It is evident from the said report that the payments have been withheld on account of non-commissioning as the raw water was not available. Stop. Neither the state nor the municipality have pointed out any deficiency in service on the part of the petitioner. Stop. No allegation has also been leveled against the petitioner that they have not performed the work under the tender as per the specification. In view thereof,
These are all water filters. They are basically water filtered plant. So, no, unless the water is coming, it cannot be installed.
Mr. Basu, Lanet Senior Counsel submits that the nature of the work contemplated under the tenders was for installation of water filters,
Water filtered plant.
water treatment plant. It is not in dispute that since the petitioner have performed their work under the contract and neither the state nor the municipality has pointed out any deficiency in the nature of the work performed by the petitioner as per the contract. This court is of the considered view. Now, and also that no, who are you?
Their contract is not only restricted installation of the power, it's a 5 years maintenance.
Why is it maintaining okay? How is it maintaining?
How it can start what they will do.
Where have you stated that in your report?
Paragraph 2H and
You are Bonga.
I am for Bonga.
Yes, paragraph.
2H and page 4. And paragraph G also. It is very much started. Bonga municipality report approved by Proceedings.
Sanjeev Kumar's affidavit is silent.
So this one is no one from our.
Yes,
No. Can you see?
affirmed Sanjeev Kumar on behalf of Bonga municipality, respondent number 4 is the Vipin Ghosh.
Next probably some mistyping.
Sanjeev Kumar.
There is no one from Sanjeev Kumar. First paragraph or second paragraph.
No, who is the respondent number 4?
Respondent number 4 is someone else, right? Respondent number 4 is more.
Yes.
That is affirmed by Proceedings, one of the councillors of the government.
Prosenjit বিশ্বাস.
Yes.
Yes, Prosenjit বিশ্বাস.
Page 4, paragraph 2G and 2H. G. Page 4, paragraph 2G. The total contract is 1970 lakhs. We have already paid 1500 lakhs. That is in respect of installation. Now what they are asking for the maintenance, which cannot be done. For 5 years, cannot be maintenance amount. Other than scrap and pipes, that cannot be done. Entire 5 years, they cannot be given first.
Wherever state that they have not done this maintenance. No, show from your affidavit, show that they have not done anything with regard to maintenance.
Specifically stated that still not operational. Still, the provision of the project could not be done due to non-availability of orders.
Which paragraph you are placing? Which paragraph? Page.
Therefore, the question of the operation of mechanical accessories of the state water treatment plant does not enter.
So the basic thing is that non-commissioning. If it cannot be commissioned, it cannot be maintained. When the maintenance question of maintenance comes, yes. So non-commissioning is due to non-supply of raw water. So if it cannot be commissioned, it cannot be maintained. So where is the fault?
And necessary training of maintenance staff, and thereafter subsequent 5 years operation.
Supply the raw water tomorrow. Supply the raw water tomorrow. You supply the.
How much they have done?
All right, you supply the raw water tomorrow.
Tomorrow
No, I'm asking you. You supply the raw water tomorrow. You supply the raw water tomorrow. You supply the raw water tomorrow. So, all right. Yes, I will clarify.
Mr. Masud, as a senior counsel submits that nature of the work contemplated under the tenders was for installation of water treatment plant. Stop. Since the petitioner have performed their work.
At this juncture, Mr. Sinal, honored advocate, appealing for the Bonga municipality submits that the payment cannot be released as the petitioners have not performed their obligation for maintaining the said water treatment plant for a period of 5 years. Mr. When it was installed, so what is the percentage of withholding this amount? A percentage has to be indicated. Where it has been indicated? Paragraph 8 of this petition.
Paragraph 3,77,000.
municipality either one they hand over. 60% only after 5 years.
All right.
They are not.
Yes, yes.
Right.
You are for Bonga.
That is
So Bonga, wait. 2A is on account of trial run. Yes.
thereafter.
So I'm coming. So trial run. So with regard to non-commissioning, that part is over. Next is security. According to you, unless 5 years is completed, they are not entitled to security. Third is supplementary bill for idle labor and periodic maintenance charges.
That is something which is not valid. That
So-
is candidate.
So no, not a question of admission. I've not recorded that it's an admission. So this is
Beyond the contract. They have said that they have done something more. Due to non-availability, their workers waited, their periodic maintenance they have to done because there was no work. For which they are charging this amount. It is something which is not valid. I did not allow that. Hey, answer.
no, there was a contract amount. So the contract with regard to this maintenance withholding of that amount, usually there is a percentage which is to be withheld in that period of what is the percentage of that contract amount? No, show me from the contract. Show me from the contract what is the percentage which you can withhold.
Fix it on Monday, my lord, next Monday I will come up.
All right. You release this 2 crore 44.
That is the recommended.
No, no, I was mentioning for the production of
Let us for the present, let us.
Come up. You are not-
Uh,
you are not-
Kindly hear the order. At this juncture, Mr. Sinha, learned advocate, appearing for the Bonga municipality submits
That the payment cannot be released as the.
that the entire payment cannot be released since the petitioner has not performed their obligation for maintaining the said water treatment plant for a period of 5 years from the date of installation of such water treatment plants. He further submits that the security deposit can only be released after the aforesaid period of 5 years. So, however, insofar as the amount withheld on the ground of trial run is concerned, this court is of the considered view that since the petitioner has installed the water treatment plant and there is no deficiency on the part of the petitioner with regard to their obligation for the trial run, but the same could not be commissioned, admittedly for lack of supply of raw water, this court is of the considered view that the said amount on account of trial run should be released in favor of the petitioner. Instead of accordingly, this court directs the Chief Engineer, Municipal Engineering Directorate, being the second respondent, to issue the written recommendation to the Chairman Chairman Bonga Municipality on or before November 11, the other matter, November 11, 2024. So, sir, who is for, how soon then you can release that amount? After the release. Mr. Sinha, learned advocate, appearing for the, make it 2 weeks. Other, then
I'm here. Oh, that's why one more.
Mr. Samanto prays for
Mr. Sinha,
Mr. Sinha, learned advocate, appearing for the Bonga municipality, prays for 3 weeks' time to release the payment from the date of receipt of the written recommendation. Mr. As prayed for by Mr. Sinha, the Chairman Bonga municipality, being the fourth respondent, directed to release the payment withheld on account of trial run as specifically mentioned under clause A of clause, no, under clause A of serial number 2 of paragraph 8 of the writ petition. Full stop. Insofar as the amount claimed by the petitioner with regard to the supplementary bill. So when the 5-year period will end,
Not the provision, but the charge that is not.
with regard to the supplementary bill for idle labor and periodic maintenance charge as claimed by the petitioner as indicated under clause C of item number 2 of paragraph 8 of the petition, the appropriate authority of the Bonga municipality shall file a short affidavit as to the points of objection with regard to the said claim. Security deposit and supplementary. Security deposit and supplementary. Yes. So Bonga is over. Now let such affidavit be filed within a week from date. Affidavit you can file within a week from date. Payment 3 weeks. Affidavit ওটা 11 তারিখ করে on or before 11.
Affidavit, such affidavit be filed on or before 11th.
11. Yes. Who is for Bosirat? It's the scenario for Bosirat. Bosirat, who is appearing? So Raiganj is also there. Here for Raiganj Municipality, Otto Kumar Nag and Deborina Ghosh. In this matter, Raiganj is there. No, I think then there is a typing. So this is 1, 2, 1, 3, 4. I think it's a wrong recording. Raiganj, Mr. Otto Kumar Nag is appearing for Bosirat.
Same, right? If I'm not wrong, same line. Could also put it at same line. That's Sandeep Kumar.
Is not here. The time. Can you inform as Mr. Nag come? Can you inquire? I'm keeping it at 2 PM for that. Because a part of you said second respondent. What requisition? The executive engineer has to give. He said he is the authority. You call for the report from the record from the executive engineer. Yes. It will be open to the.
Don't submit that back.
It will be open to the second respondent to call for any report or papers from the executive engineer, from the concerned executive engineer for issuing the written recommendation. দুটোতেই করবে। Yes.
I don't think that
He is not appearing for Otto Kumar Nag and Deborina Ghosh. So I'm keeping it at 2 PM. And if anyone appears, you can inquire who appears for Bosirat. Shall I keep it at 2 PM? Returnable yes, insofar as this matters, let it be returnable after 3 weeks because he has taken 3 weeks. Yes, সবকটাই after 3 weeks করে 3 weeks এর ডেটটা করে দিও। আরে 11 এর পরে 3 weeks চেক করে After 11th, it shall be 3 days. Or shall we do one thing? Any date after 11th, let us see what then.
No,
Uh, 11th পরেই রাখুন, নাহলে আবার বলবে যে ওই
Maybe
12
12th.
তারিখ রেখে দিন,
12th.
12th রেখে দিন, 12th রেখে দিন। Yes,
one to six, eight is state code.
you do your part, thereafter they will do their part. For all of your benefit, I'm just saying God bless. Yes, call the next matter. No, you did not need. Mr. Samanto, you appear. Yes, because you are for the state. Yes, call the next matter. Oh, at the line at Mr. Basit, you have posted that amount. Mr. Basu,
The number is A number is not given.
Mr. Basu, account for Mr. Basu, Lanet Senior Counsel submits that as per the earlier order dated, such deficit court fee order. The deficit court fees have been paid on. Give the date. Mr. Basu only ask you has been paid on blank লিখে দিন দেখতে দেখেছেন আর filing number যদি কিছু নাম্বার থাকে সেটা দেবেন
Nowadays it is not given that.
some number has to be given
Nowadays it is not.
some number has to be given challan number or something. Yes, call the next matter. What happened to the matter before the division bench? Judgment not yet been delivered. They said that the issue is same. No, yes, challenge these some rules of that leave rules. They said that it was under challenge. That is why I have recorded that. For which you have declared the vacancy.
Yes, but you can so clear that you are that she has 7 documents by the petition also by the PI and all other
It's an end of the matter then. Let them take a decision, you appear. It's because they say that they want to give you an opportunity, they want to consider your representation, so nothing is left then. Ashwin, Mr. Ms. Bhattacharya, honored advocate appearing for the West Bengal Board of Secondary Education submits that she has received instructions from the board that the board is contemplating to consider these several representations submitted by the petitioner before the boards, before the school authorities, as well as before the school authority as well as the board, and to take a decision upon giving a hearing to all the necessary parties. Mr. Baril, honored advocate appealing for the petitioner, seeks an accommodation to take instructions from his client. Mr. As prayed for by Mr. Bani, list this matter on Thursday. Thursday. Take instructions. If they consider your representation, you can raise all points there. Does not come. You cannot start the hearing. Thursday you can produce the records. Your officers will be available on Thursday. I'm making it not today. Not today. Yes, next. Six continuing matter. Why? It was hard.
December.
May I mention one thing? This matter I have not been in this by mistake, but my name is appearing. You all see that it's
You can appear in this matter. Who is appearing for the state? Why your name is appearing? Where is Mr. Dotto? Who is for the municipality? You are for the municipality. Yes, this is the same thing. Objection also same. So, unless written recommendation is given. Written recommendation from the municipal engineering department is given to you, you cannot release the payment. Yes. But where is Mr. Dotto? In the absence of Mr. Dotto, Mr. Basu, how can it be done?
I know that. But what comes when it comes to paragraph 72?
What is the
Justify by the past day.
Asu?
Question for you.
Asu.
When it comes come,
Mr. Basu Lane, senior counsel.
no, people are saying there's something like you must be by the
What I have said,
we can use it also if it's one paper.
Report. Where is the report?
instruction, not a
Instruction. This is instruction. Mr. Basu Lane, senior counsel representing the petitioner, submits that the municipality is not releasing the admitted dues to the petitioner on account of the work done by the petitioner as specifically stated in paragraph. Specifically in paragraph 17 of the writ petition. Poster.
There's some additional work that also admitted.
The learned advocate appearing for the Krishnagore municipality submits that the municipality has not yet received any bill. Yes, after that you have not received any bill. This is your written instruction. I'm recording that.
That municipality have not yet received you.
Because I have,
Has not yet, has not yet received any bill from the municipal engineering department after the last payment made by the Petitioner municipality on 31st of August 2020. A written communication of the chairman Petitioner municipality dated 19th of September 2024 addressed to the learned advocate on record of the petitioner is taken on record. Oh, sorry, of the municipality is taken on record. Mr. None appears for the. There are other municipality also. Balughat, it is the Kishnonagar. Kishnonagar. And what is with regard to the other municipality? Same thing. The learned advocate appearing for the Bardwan municipality, so Balughat municipality submits that the payment could not be released in favor of the petitioner as the written recommendation from the municipal engineering department has not been received by the municipality. None appears for the state. Mr. Samanto, learned advocate, who usually appears for the state, is present in court today and is requested to appear in this matter. No, the state has filed any report. I can engage Mr. Samanto, but he will again take time to take instructions, or you can inform Mr. Jawahar. What do alright, কি বললাম Mr. Samanto, learned advocate,
Usually appears for the state
state
legislative court.
who usually appears for the state submits that through inadvertence his name has been recorded as the learned advocate who appeared on 13th of September 2024 for the state. It is recorded that Mr. Samanto, learned advocate, did not represent Mr. Samanto along with his junior Mr. Kushal Vishal did not represent the state on that date. Be careful, Mr. Samanto. For other purpose, so did not represent the state on that date. It appears from the record that Mr. Jawahar Totto appeared for the state on 6th of May 2020. The learned advocate and record of the petitioner is directed to intimate the next date of hearing to the learned advocate appearing for the state. List this matter on 12th under the same heading. 12th of November. This for the petitioner. You are for the petitioner. Why? What is this matter?
Say that directly to take instruction, stage of the proceeding. It is yet to be late, but the consequence is to take that whether can be done by virtual court or the net will come, by will come to the court. On a single day, I have to prosecute completely confidence on the very same day. Consequence that
an accommodation has been paid for on the ground of the learned advocate for the petitioner, Mr. as paid for by the learned advocate for the Mr. Samanto, learned advocate, appears for the opposite party. Mr. as paid for by the learned advocate for the petitioner. List this matter in the next. it is clarified that pendency of this application shall not preclude the learned judge of the court below, learned trial judge from proceeding with the hearing of this. Next. Yes, next.
Eight.
Four and five. Mr. Banerjee for the petitioner. 1996. Anything is left, Mr. Banerjee, in this matter? What is the issue? There was a suit. There was a suit. There was a decree.
What is this? Should be taking your judgment in the issue.
So the suit was dismissed.
But from the ground.
You filed the suit. You filed the suit. What was the suit for? What was the declaration sought for? No. What was the declaration sought for? Declaration that you have title to the property. So you prayed for a declaration that you are the owner of a shop, and for permanent injunction restraining them from disturbing your possession or to take possession from you. That suit was dismissed. Jagdal Gupta. No. Who is the petitioner number 3? Yes, Jagdal Gupta. He died. Yes, sir, not on record. Yes, yes, sir, not on record. When did he die? Long back. So abatement also took place. Abatement setting aside is nothing but to explain the detail. Separate period setting aside section 5 that are given, but you have to explain. And more so you are the petitioner. Since there is no period prescribed, Mr. Banerjee, learned advocate appearing for the petitioners, submit that in the meantime, that during the pendency of the writ petition, the petitioner number 3, namely Jagdal Gupta, has passed away. Mr. He prays for some time to take steps in this regard. Mr. Let the matter go out of the list with liberty to the petitioner to take appropriate steps in this regard. Learned advocate for the, you are for the Union of India. The learned advocate for the respondent number 4 and 5 is present. Then out of this the point. Yes, next.
Seven.
For different matters.
11.
Content.
May it please lordship, my lord, I beg to appear in this matter on behalf of the petitioner. 11.
Mukaji, you are appearing for which item?
Petitioner 11, item number 11.
11. Item number 10, who is appearing? So, what is, but why it was tagged?
We cannot get clear issue
Alright, so let all the matters appear along this because those were hard. So there also he died. Acha, item number 10 and 5 এটা না আইটেম নাম্বার 9 এর রিফিক্সন নাম্বারটা দিয়ে লিখবেন না তো ম্যাটার একসঙ্গেই আছে বিট করে আছে তো তাহলে ওই রি বলে তাহলে ডাব্লিউপি নাম্বার ওইখানে থার্ড পিটিশনার এখানে পিটিশনার সঙ্গে চেঞ্জ হয় তো 8 নম্বরে
11 থেকে
8 নম্বর Mr. Mukherjee, I am at item number 10. I am passing a formal order recording the death of one of the petitioners. Then I am coming to 11. Mr. Banerjee, which petitioner died? Mr. Banerjee, learned advocate, appealing for the petitioner submits that during the pendency of the writ petition, the writ petitioner number 2, namely Goya Prasad Singh, died. Mr. He prays from some accommodation to take necessary steps in this regard. Mr. The respondent numbers here also 4 and 5. Respondent numbers 1 and 2 are represented by their learned advocate. Mr. Let the matter go out of the list with liberty to the petitioner to take appropriate steps in the meantime. Yes. Call item number 11.
Lord, I beg to appear, my lord, on behalf of the petitioner. My lord, an application is appearing before lordship for hearing.
Mr. Mukherjee, is it the matter of Bonik Rubber Industries?
Yes.
Then Mr. Some difficulty of mine.
Entire your lordship's pleasure. Yes, it's Bombonic industry.
Count of personal let the matter be released from the list of this bench. The petitioner will be at liberty to take steps upon strictly upon notice to the respondents.
Great to lordship.
Sorry, Mr. Mukherjee,
No, my lord. It's entirely your lordship's pleasure.
because the name struck me. Thereafter, I have seen the cause title to be more sure. Yes, call the next matter.
12.
My application, my lord, section 5 application.
Restoration.
So which section 5? While my lord, evidence will show that the municipality is the original respondent. Municipality has already been served, but the private owner 5. No report has been. There is a delay, my lord.
You are for the petitioner.
Into one of the mistake.
What is the
Down only, my lord, the learned advocate.
who appeared for the private respondent?
One Indrajit. Private respondent, my lord. It don't appear. Yes, Banerjee. And
Serve
Joydev
him.
Yes, Banerjee and Joydev Acharya.
It was dismissed long back, 2022.
And why not?
You have also not served upon the municipality.
Yes.
Municipality has been served.
Municipality even
Mr.
lawyers.
Bhattacharjee, learned advocate appearing for the petitioner,
and every
submits that though the restoration application has been served upon the learned advocate appearing for the Kolkata Municipal
Yes.
Corporation, but the private respondents have not been served. So stop. As prayed for by Mr. Bhattacharjee, list this matter in the next week. In the meantime, the petitioner shall serve a copy of the restoration application upon the private respondents or their learned advocates. Because 2022, nobody knows whether they are appearing or not. And to file an affidavit of service on the next date. Yes, call the next matter.
And I find the ability of service.
Thirteen,
My lord, I am appearing on behalf of the petitioner led by Mr. Rohan Banerjee, my lord.
What is
This-
the application?
This is the restoration application, my lord. The affidavit of service is 9 February. The matter was dismissed, my lord. It is within time, my lord. I have served all the parties.
For respondent number
2019 writ petition, nothing is there.
Yes, my lord, it is there, my lord. The affidavit has already been completed. If your lordship kindly fix the main matter, my lord, for
Yes,
hearing.
argue the main matter.
Main matter, my lord.
There is no other private party
Yes, my lord, there is a private party.
who is
Who, on whose favor the oil company issued the,
have you served him?
yes, my lord, I have served them.
The restoration application was within time, my lord. Let
Yes,
them
sir.
serve that the hearing would be taken up. At least they
Yes, my lord.
have been allotted with the distributorship and they are.
What is the
functioning.
issue?
My
Issue
lord,
is the selection of the distributorship, my lord.
yes, my
As
lord.
a matter of fact,
Ask your
that
junior to inform Mr. Arjun Rai Mukherjee.
yes,
If
my
they
lord.
come, the main matter can be taken up.
Yes, my lord. He was appearing on behalf of the private respondent on the last occasion. Also, he's appeared at the motion stage before Honorable Justice Sharaf. As on date, your
Is that the motion stage?
No,
That was in the motion stage.
initially
Now,
it was admitted and affidavit of, there is a direction for affidavit was given.
has
Both
been
the parties have given the affidavit in
as
opposition.
on date, your
reply.
lordship is absolutely correct, my lord. There is nothing remaining in this writ petition.
Not
Your
my lord,
lordship, of the hearing, I have no. I'm ready.
অর্জুন রায় মুখার্জি ফোন নাম্বার আছে মানে
Matters, my lord.
না না তাদের সাইডকে ইনফর্ম করতে বলে
Has he come, Mr. Arjun Rai Mukherjee?
no my lord, his phone number is not with me, my lord. I have informed Mr. Rohan Banerjee, he is leading in this matter. I have Mr. Partho Pratim Dotto is the junior. I have informed
You have
him.
informed him.
No, I
You have his phone number.
just
Ask your junior to inform him.
Yes.
To start the hearing of the main matter. Yes.
ফোন নাম্বারটা দেখ ফোন নাম্বারটা যদি দেখ এখানে আছে ওই অনেক ওর অপোজিশনেই পারে My lord, we have challenged the selection of the private respondent on the ground that initially the private respondent given one land for is a
This is LPG.
LPG distributorship.
So initially he offered one land.
One land.
Thereafter he has changed that.
Change, and it was not within the purview of their advertisement. Subsequently, they have changed another land.
I think there is a clause in the advertisement
Yes, my lord,
permitting
there's
such
one.
change.
They can change only one. They only change only one time, my lord. But they have changed if they are if your lordship considered the affidavit in opposition of the oil company and the private respondent, they have changed 3 times, my lord. But as per the guideline, my lord, they cannot change in the subsequently they cannot change their land, which is
According to you, the terms as stipulated states that it can be changed only once,
only
not
once.
more than. Show me that clause.
The advertisement in page 20, my lord.
Page?
Page 20, my lord, the advertisement.
Yes.
My lord, in page 21,
Yes, page 21.
the last, my lord, there is the Sadharon Shortaboli. It was written, my lord. Reply টা আমরা মনে হয় পুরো কেসটা মেক আউট করেছি। রিপ্লাইটা ওখানে আছে।
Yes.
My lord,
সাধারণ শর্তাবলী।
my junior informed that the Mr. Parthabuddin that has not come today.
Mr. Banerjee, you don't have the phone number of Mr. Arjun Ram Mukherjee?
Arjun Ram Mukherjee, yes, I have his number. I can
তাহলে নাম্বারটা
call him.
ওরা
So,
he
No, I can try to contact him and ask him.
ask your junior to contact him.
he requested that if your lordship kindly fix it on Wednesday.
He has established contact, not request has come from the council that if it is
Council
taken,
না পারতো junior যে advocate on
advocate
record.
on record that if it is taken up not on any day. That is not. But point one has been not portrayed by my junior very shortly that one chance can be given during field verification. More than one opportunity has been given, which is not permissible. And the document on the basis of which it was cancelled, redraw was fixed. Then it was again cancelled at the instance of the private respondent. But the document which she produced, that is also ineligible. There is no road, it's no accessible road. That document on the basis of which first chance was given, that is a bad document.
But
the
the
other document, subsequent
godown has been set up. Distributorship.
he has started.
When?
Not at that point of time when the writ was moved.
Yes, when that?
19,
Which year?
2019.
19, 24.
Not upon affidavit, your lordship is hearing. If I can establish that the guideline has been not followed by the corporation
No,
while giving, because initially,
সাধারণ শর্তাবলী, which clause?
may I just show the clauses one by one. If your lordship takes up the opposition of the Bharat Petroleum Corporation Limited,
Senior was pointing out something from page 21.
page 20.
সাধারণ শর্তাবলী।
এটা হচ্ছে মেন কন্ডিশনটা।
These are the conditions, my lord. They have annexed the documents on the basis of which they have given the relaxation. I'll just show those documents from the opposition of them, BPCL. Reply to four.
Page
I'm filing my affidavit in reply, my lord.
opposition of
Opposition, lord. First, lordship kindly come to
Hindustan Petroleum.
Hindustan, Bharat Petroleum. Bharat Petroleum. Four.
ওটা একটা রেকর্ড করে নিন। এফিডেভিট ইন অপোজিশন ফাইল বাই দি রেসপন্ডেন্ট নাম্বারস 1, 2, 3 মানে 1 TO মানে 1, 2 আর 3 এর and the reply there too are taken on record. Mr. Banerjee, you are filing the affidavit of service.
Reply, my lord.
No,
No,
service
this
is
also-
the restoration.
Service also you are filing today.
This is the restoration, service of the
Service
restoration.
of
The affidavit of service
reply to the
filed by the petitioner in connection with Can 1 of 2024 is also taken on record. Yes,
kindly takes up page 22 of the opposition, my lord.
22.
22.
Yes.
If the land offered by the candidate in the application,
Which point you are
clause 2B. 2B.
2B? Yes.
If the land offered by the candidate in the application or alternate land offered by the candidate at the time of field verification meets all specifications as laid down in the advertisement on the basis of which LOI has been issued, then the LOI holder can offer an alternate new land for construction of godown of specified dimension in the advertised location, which will be considered on the ground of enhanced security. So, my lord, the land which was offered has to meet all the specifications. Then subsequently,
motorable approach road.
approach road of 2.5 meter, which was not available to the alternate land which was offered during field verification. They have offered an alternate land during field verification. That is the case made out. That land was not having the requisite criteria which is required for setting up the godown. So at that point of time they were gone, but their case was kept alive, and subsequently they have purchased another land and offered that subsequently after the advertisement. So subsequent offering the land is bad.
Had they, my lord, offered the land which was requisite at the time of field verification, then they could have offered an alternative land subsequently. But they did not have that land at that point of time. This is not the sum and substance.
So according to you, at the time of field verification, the alternate land must meet all
All
specifications.
specification.
According to you,
They have,
that did not meet all the
did not have the, I
specifications.
have annexed the deed.
So where
my
is your averment with regard to
my
this?
lord.
And what is their
In my affidavit
reply?
reply. In my reply, I have stated, my lord.
No. In your writ petition, you have made out this case.
In the writ petition, I have made out that not his original land was not, my lord, meeting the specifications. In opposition, they said that yes, but during field verification, they have offered one land. Subsequently, another land was offered,
Yes.
which meets all
So
the
in the
requirements.
reply, you have said that the alternate land did not meet. So
And
they did not get any opportunity to controvert your this statement. This is a statement on oath.
but if they want to, they had the opportunity to use a sari joinder. They have not sought for that.
But you have
Could have-
either you are making out a different
Because-
case on facts in the reply.
No, I am only meeting, my lord, the case made out because these documents are not
According
available
to
to
them,
me.
it also meets the specifications. You come out with a case in your reply saying no. Did you? Yes. All right. Let
Because
me
not
see.
this clause,
What have you stated in the reply?
my lord. May
What is the violation?
I state it? Kindly come to paragraph 4, my lord. May I place? Paragraph 4 onwards.
Paragraph 4.
Yes. 4A.
For the paragraph which contains several subparagraphs.
My lord.
Which subparagraph?
May I just read out not the 4-5 subparagraphs so that my case is not what case I have made out, it
No,
becomes clear.
That is the alternate land. Show me that what is your objection with regard to that alternate land?
My lord.
Why did it, according to you, it does not
Fine.
meet the specification?
Kindly
Show
come
me
to
that
paragraph
relevant
B.
part.
I state that the alternate land,
Which paragraph?
paragraph 4B at page 3 of my reply.
4B, yes.
I state that the alternative land which the private respondent relied upon for getting the distributorship was not suitable for awarding LPG distributorship. The said land is not suitable for setting up a godown as it is a jol jomi and surrounded by jol jomi having no approach road. It has been ascertained by the writ petitioner from the Moja map and through verification by the government registered Amin, it was revealed that there was only a 3 feet wide village path which is not suitable for approach of the heavy vehicle.
So there is a village path of 3 feet. So in
motorable
that
it has to be a 2.5 meter motorable road.
village path,
It is
motorable
Jol
road.
Jomi. Jol Jomi, my lord, cannot be, my lord,
You
used
have
for
not
good.
said Jol Jomi.
Yes. I have stated, my lord, Jol Jomi. Kindly
one
see
annexed
fourth
আছে।
paragraph. I have annexed the deed also. Deed also says Jol Jomi.
ঠিক না, ইয়েতে
No.
And
One
I have also
is
পর্চা।
the land is Jol Jomi. There are two aspects. One is the land and another is the approach road.
approach road.
With regard to your approach road, you have stated that there is a village path of 3 meters, of
No,
3 feet,
3 feet.
of 3 feet. And in their opposition, that clause you have stated, it says 2 to 3.
I have said that the 3 feet path is not suitable for approach by heavy vehicles.
Give me a
It has to be, my lord, a path by through which I'm not heavy
Oh,
vehicle
minimum of 2.5
meters. For, my lord, approach by a
লরি
lorry or truck carrying, my lord, the cylinders. It has to be a road.
Yes.
So it has to be, my lord, a proper road, which was not there. Then, my lord, moreover, it appears from the information maintained by the BLLRO that the said land is classified as Jol Jomi, which is not suitable for setting up of LPG godown. Said contention of the writ petitioner has been proved from the conduct of the private respondent. Since the Jol Jomi is not fit for godown, private respondent submitted another land for construction of godown and showroom, which he has purchased subsequently.
So according to you, since that land was not
Not
suitable,
suitable,
the
you cannot offer
another
up-
opportunity could not be
have
given.
been given. And not his candidature was cancelled, redraw was fixed. Then they have not done all these things. That land was not suitable. These not the
Yes, Mr. Chakravarti.
My lord, there are 3 phases, my lord. First, the eligibility conditions are tested during field verification stage. My lord, I will show from the guidelines.
What was the plot which was offered at the field verification
field
stage?
verification stage?
Show me the plot that was offered at the field verification stage.
আমরা দিয়েছে না হয়তো আবার দেখানো তো আছে not page 49 of the opposition, my lord. Possibly subject to correction.
Because according to point 2B at that time, it must meet all the specifications.
Yes, my lord, but what I am submitting that the field verification stage, if it is found that it does not fulfill the eligibility criteria, guideline provides that he will
Show me that.
guidelines.
My lord,
Page
kindly come-
22B says, kindly come to page 22 of your opposition,
Yes,
clause
my lord.
B.
Yes.
Kindly place that.
If kindly sees if the land offered by the candidate in the application first
Yes.
or alternative land.
So this was the alternate land.
This was the alternative land during field
Then
verification
proceed, then
stage.
proceed, then proceed.
Yes. Offered by the candidate at the time of field verification
Yes.
meets all specifications.
As laid down in the advertisement.
Yes.
On which LOI was issued.
Issued. This is the next stage, my lord.
Yes. So
Field
show me
verification
the
stage.
alternate land and satisfy me that it meets all the specifications
Yes.
as mentioned in the advertisement.
Yes, my lord.
এই তো ও নিজের এলিজিবিলিটি বলছে ফিল্ড ভেরিফিকেশনে ও একটা নতুন দিল ঠিক আছে তো ডিউরিং ফিল্ড ভেরিফিকেশন আই ডাইরেক্টেড এর অল্টারনেটিভ ল্যান্ড ঠিক আছে
This is the short point.
তারপরে
Show me that plot
cancel হলো।
meets all specifications as per the advertisement.
বলেছে
May I
His
just-
opposition, he has said, during field verification, he has given one land, then subsequently
No,
after
no,
LOI.
change might be there, might be two things. It meets the specification, he can change that.
Yes, if it meets.
But according to you, it does not
not
meet the
meet.
specification. Let him satisfy that it
Ma-
meets the
May I just,
specification.
I will indicate, my lord, whatever. Otherwise,
Tell it
they are
or-
from their affidavit, my lord, private respondents, my lord. First is thing, during field verification, inspection is conducted. If it fails to satisfy, an offer can be given or the candidate can offer a land meeting the eligibility conditions, on the basis of which letter of intent is issued. Now, after receiving the letter of intent, there is a specific provision. He can offer, the eligible candidate can offer a new land.
Yes, yes, yes.
Yes.
But
Now,
first he
what
has
I
to
have
cross
to-
the first hurdle. Show me that at the time when the LOI was issued, that the land which was offered met
The
all the
eligibility
specifications as per the advertisement.
Yes, my lord. Now,
Show me that.
Page
What was
49.
the land which was offered? Show me the
Page
document.
49,
Show me your advertisement. What was the specification?
page 49, my lord, the deed. The next
49 of?
of their opposition.
Yes.
Page 49 and the schedule is at page 54, kindly see. All surrounded by Jol Jumi. So, Hodi, kindly see.
my lord, Jol Jomi is not a condition precedent, my lord. I will show from the,
No, I am
Uh,
not saying Jol Jumi. I am saying that there is no approach road. Kindly
Yes,
see the
my lord.
Chowhodi.
যেখানে লিখে রেখেছে
I will show from the brochure, my lord. Approach road not is the condition precedent.
What is Joljomi, Mr.
Jol
Chakraborty?
Jomi, my lord? I will from the
No, no, I'm asking you, what is Joljomi?
inundated in water, my lord. This
What is the classification?
classification,
Jol.
Jol itself does not mean.
No, what is the classification in the record of rights with regard to that plot of land
Page
which he has offered?
record of right
In my reply, I have annexed the record of right, page 11.
What was the classification,
Jol.
recorded classification?
Jol.
But that was subsequently changed, my lord. My brochure does not say that the classification on the date
Show
of.
me the converted, the corrected record of rights. Show me the conversion certificate, when it was allowed.
audit petition টা বের
There, my lord. If your lordship,
Show me that, because you are satisfied with that.
করো।
It must be with you.
রাত নাম্বারটা বলো।
but not annexed with the affidavit in opposition, my lord. But that is there, my lord. Unless that is there, there cannot. Your lordship, if requires, my lord, I will file supplementary affidavit.
No,
to
it
that effect.
Chowhodi is there and so record of it is also there.
And my
Kindly
lord, what is the matter
ওটা তো বলছি।
that this particular term, Jol, has been explained by this court, my lord, by this honorable court.
RSI
That Jol does not mean that it
It's all right.
cannot be converted.
see.
in the-
Mr. Chakraborty, I have not said for a moment that it cannot be converted.
Yes.
There is a provision in the West Bengal Land Reforms Act for conversion.
That was.
I'm asking you, show me the corrected record of rights after it was converted, when it was converted. Show me the conversion certificate. I'm asking you because you must be provided with that.
Yes, my lord, I have in my office, my lord. That is there, my lord. I can place. Without having the conversion, my lord, the go down cannot be. Because, my lord, that has to be with a license from the peso as well as.
And what is the, with regard to approach road?
Approach road,
Show
my
me
lord,
from this
after.
deed.
That is not the condition precedent at the FVC stage. I will show you that the approach road has to be in tune with the brochure or the white after the LOI, I will the specific guidelines, my lord. Yes, my lord. Approach, there is specific provision.
Show me that.
Yes, my lord.
Approach road, what is the condition mentioned in the advertisement? First,
Absolutely.
show me that.
Meter. Absolutely, meter. Approach road, kindly comes to page 27, my lord.
Of your opposition.
Yes.
Page 27, yes.
The candidate should ensure, your lordship received it. The candidate should
Yes.
ensure that all-weather motorable approach road of minimum 2.5 meter width is made available. Ensure at the godown within the stipulated time period specified in the letter of intent, not during FVC, to provide access to LPG cylinder truck to be offered land or godown LPG godown. In case of private road connecting to the public road, the same would be either owned, registered lease, or having right of way from the owner of the land. In case there are any state-specific requirements, norms applicable for the LPG godown approach road, then the same will be applicable for the respective distributorship locations, including revised minimum dimension of the plot of land. Now, your lordship comes to the last paragraph. An undertaking will be required to be provided by the selected candidate at the time of acceptance of letter of intent, that the approach road as specified will be provided within the time frame as mentioned in the LOI. The approach road will be verified for its suitability before the issuance of the letter of appointment. It should be the responsibility of the selected candidate to ensure that the LPG cylinder truck is allowed unhindered access to the all times through this approach road to the LPG godown upon commissioning of the LPG distributorship.
Yes.
In the event of failure. So, it is not the condition precedent at the FVC stage. Later on, he can also construct the approach road himself or by the local authority.
From
and
where
get
is
it.
getting that?
So show me from the deed which was produced before you that there is a motorable road.
That was not the
This condition has to be satisfied
yes.
at the time of, show me from the deed
Not at
which
the
was
not at-
offered. Show me from the
not
plot.
not at the time of FVC, my lord. After field verification, letter of intention is issued. That was the condition.
At
So-
the time of field verification, the plot which was offered at the time of field verification, it must meet all the specifications.
Specification so far as the road is considered may
Yes.
not be fulfilled. May
What?
not be fulfilled.
May not be fulfilled.
Yes, my lord. That is the condition. He will be given a time.
So you can show any plot of land. So what is the purpose of field verification then? Mr. Chakraborty, take a pragmatic view. What is the purpose of field verification then?
Eligibility conditions to test the eligibility
So
condition. which are-
anyone can show any plot of land and then can change it. So you will not see anything at the time of field
I
verification.
have to see whatever has been
So
provided
motorable approach road is not necessary from at the
for
time of,
at the field verification stage.
not necessary.
No, my lord. To my humble submission.
Show me from here that at the time of field verification, motorable approach road is not necessary. Then what is the
That
purpose
I have
of?
placed before your lordship that approach road has to be after LOI. Field verification thereafter LOI. LOI in the LOI time is specified within which time he will have to construct the approach road as well as the godown. The brochure does not say that the classification of the land has to be changed at the time of field
So it can
verification.
be kept pending also. He has to apply. Time can be given.
Unless-
He has to give an indemnity.
Yes,
If
for
I'm
this
not
approach
wrong,
road.
yes,
For
that
this
he,
approach road.
yes.
After during FVC, what I am submitting before your lordship is that at the time of field verification, it is not the essential
If
condition.
the plot in question is surrounded by water bodies or lands inundated with water without converting, can a permission for approach road be given?
He will be he has,
And such plot is not owned by this private respondent.
we
Whether he can apply for conversion of that, for construction of
but we
approach
cannot
road.
presume, my lord. We are not the authority.
I'm asking you. I'm asking you.
Yes, my
As an
lord.
officer of the court, so if the plot of land offered
Lot of land
is
inundated with
surrounded
water.
by lands which are inundated with water, which does not belong to the private respondent, can an approach road be constructed and on such land and permission for conversion be granted?
But whether permission can be conversion can be granted or what, whether he can. Really,
Mr. Chakraborty, you are an authority. You have to see what is possible or what is not possible.
but that I
If
cannot, my lord. I
that
will,
is not
my lord,
possible by a person, can he apply for conversion of another person's land?
but he,
And he can construct a road thereupon.
but we have no jurisdiction to travel into that matter. Being the officer of the court, as well as the officers of the IOC cannot travel into the matter, whether that can be
You
converted.
have the field verification report with you.
We have the field verification report, but the field verification says, what can I do?
No, do you have the field verification report with you?
Yes, my lord, I can place the same before you,
All
your
right.
lordship.
Okay. Mr. Banerjee, learned advocate, appears for
Kindly just.
No, they cancelled his candidature. His candidature was cancelled. Then a
No,
writ petition was filed.
There was another writ
Writ
petition, my
petition
lord.
was filed, then they withdrew.
Another writ petition.
Mr.
That was
Banerjee,
also
learned advocate, appears
Just
for the
indicate, my lord, if your lordship
petitioner.
kindly allows.
Mr. এটা ক্যানেতে order করবে না? This is an application for restoration. Stop. In spite of service, none appears for the private respondent. Stop. Bharat Petroleum Corporation Limited is represented by its learned advocate. Stop. The learned advocate on record of the petitioner is directed to intimate the next date of hearing to the learned advocate for the private respondent. Stop. List this matter. List the application on Thursday date.
Restoration is allowed, my lord.
He is not here. I will hear the
Just,
make
just,
communicate
my
to
lord,
him. I will
for
hear
this
the main
purpose,
matter.
Page 27 says, my lord, although I will, that the land for construction of the godown should be plain in one contiguous plot, free from live overhead power transmission or telephone lines, canals, drainage, nalas should not be passing through the plot, my lord. Water body specifically has not been incorporated in the procedure.
Chakraborty, since I have not formally allowed the restoration application today, I am
Very
not
well, my lord.
directing
I
you.
have,
You have the records with you because
very
on the
well, I
next
will,
day,
this Thursday, my lord, in the meantime, may not be possible for entire documents to be before your lordship. Kindly allows me some days, I will be, what?
from where you will bring Mr.
From the office, my lord.
Where is your office situated?
But it is not in the, yes, my lord, golf green, I understand, but that is not there, my lord, in Durgapur area.
Can be brought.
Some 10 days at least, next Monday, my lord.
হয়ে যাবে, দেখুন না, হয়ে যাবে।
Yes,
বললে ওরা ছুটে আসবে।
list this matter next Thursday. Next.
আচ্ছা,
14,
Lordship, appearing for the petitioner in the contempt application, Your Lordship.
Yes.
Lordship, on the last occasion, Lordship was pleased to direct the petitioner to serve a copy of the contempt application upon the then contempt, Your Lordship. In the meantime, the Pradhan has been substituted. There is a new Pradhan, my Lord. I am praying for liberty, Your Lordship, to serve the contempt application upon the incumbent Pradhan, my Lord. And
As prayed for by the learned advocate of the petitioner, leave is granted to the learned advocate on record of the petitioner to implead the present Pradhan of the concerned Gram Panchayat. First up, the petitioner is directed to serve a copy of this application upon the newly added alleged contemner. First up, list this matter after 2 weeks. This
Grateful.
application after 2 weeks.
gratefully, Lord.
Next.
Lord, pursuant to your Lordship's direction, I have served, Lord, it has returned as deceased.
Release. Husband.
Nothing can be done.
Remark is correct.
Lord, that's correct. I have verified. I had asked her. She had verified.
You are responsible for that, Mr. Kormakar.
Kormer fall.
What is the... This is a contempt application.
Contempt application. Now, Lord, the pension she will directly get. The pension that he used to get, she will directly get it.
What was the suit for?
Suit for divorce.
Suit for divorce. What is the stage of that suit?
But arguments were going on. And I had also inquired, my lord, he had a son from a second marriage also. Rather the first marriage. He had a son from the first marriage. Unfortunately, he has also expired.
Hmm?
He has also expired. My lord, she is the only available legal heir. My lord.
So, is anything left in this contempt application, Mr.
If the
Kormokar?
contemner dies, my lord, in any event, my lord, and nobody can pursue the case
Because
also.
your claim is money claim.
Yes.
So, realization from that, whatever dues, anything which the petitioner is entitled, which the husband was entitled to. Now, if you are entitled to
I'll
the
get directly from-
pensioner,
Yes.
so suit filed by the husband.
By the
Now, what is your submission now?
now kindly records it, and Lord, what else, Lord? In the contempt jurisdiction, Lord, I cannot press anything. The only thing, Lord, kindly records the death, Lord, so that I can take this, because I don't have a death certificate. Nobody is giving me the death certificate.
You are filing the affidavit of service.
Yes. And Lord, he has died on 2nd of August 2024.
Where from you came to know? Where
Lord,
from you
that
came?
from inquiry, from the inquiry.
So I'm not mentioning the date. The affidavit of service filed in court today.
But only one prayer, Lord, kindly records my submission that from inquiry I've come to learn that it's on 2nd of August. Kindly records my submission.
Affidavit of service filed in court today is taken on record.
On the reverse side.
Mr. Kormokar, learned advocate, submits that the registered envelope addressed to the alleged contemner returned with the endorsement, double inverted comma moddhe, deceased. He submits that he has been instructed to submit. Now, he submits that he has received instructions from his client that the alleged contemner passed away
August 2nd.
sometimes in the month of August 2024.
2024.
First up, he submits that nothing survives in the contempt application in view of the death of the petitioner. First up, recording such submission, the contempt application stands disposed of. The petitioner will be at liberty to take appropriate steps in accordance with law.
Okay.
Client is responsible for all these events. Yes.
16.
I am appearing for the petitioner, my lord. This matter relating to my compassionate appointment. My lord, on the 15th March 2022, my lord passed the order. The BDO ought to pass a reason order within 12 weeks, my lord. The interdepartmental communication is also canvas that BDO sit tight about the matter. The
Who appeared in
my
the
lord, earlier, there is a direction for serve the copy. I serve the copy upon the BDO, my lord. My lord, the BDO service, my lord, kept on record, my lord. Alleged contemner is the BDO Golshi 1. Devlina Das, my lord, the BDO Golshi 1. My lord's order, which is annexed with my writ petition, page number 19, my lord, the operational portion, page number 24. The interdepartmental communication, page number 31, my lord. Kindly turn page number 31, my lord.
Yes. Anyone appearing
I
for the state?
serve the copy upon the contemner, my lord. But
Yes, I've seen that. Any learned advocate who appears for the state?
no one, my lord.
You appear for the state? Madam, can you appear in this contempt application? The affidavit service filed in court today is taken on record. In spite of service, none appears for the alleged contemner. Such and such learned advocate who usually appears for the state is present in court today and is requested to take instructions in this matter. Let a copy of the contempt application be served upon her in course of this day. List this matter under the same heading after 2 weeks.
Kindly regularize.
Let the appointment.
Regularize, otherwise, well, let's.
Yes, let the appointment of such and such be regularized by the legal remembrancer. Next.
17.
Housing both matter contempt application.
My lord, item number 17, I appear for the alleged contemners, my lord. But on the earlier occasion, it was intimated to your lordships that the appeal has been preferred from your lordship's order, and thereafter an appeal is pending before the Honorable Supreme Court. There are certain defects, my lord, that are being cured, my lord, on the last of.
Has been cured.
No, that steps are being taken for being cured, my lord, and will be listed in the month of November. But I am not handing over the copy of letter has been issued by the advocate on record. I am not handing over because that's only a letter, my lord. There's nothing from the official website of the Honorable Supreme Court, but the situation is that the defects are being cured and will be listed in the month list of November.
So I'm keeping it in December because the matter is pending before the Honorable Supreme Court.
It is pending since it is pending since August, my lord.
They have a right to prefer an appeal.
Yes.
So they say that it's expected to be heard in the month of November. The learned advocate for the petitioner is present. First of the learned advocate appearing for the alleged contemner submits that challenging the judgment passed by the Honorable Division Bench arising out of the where was the order? My order dated?
My lord, 25th September 2023. But your lordship has passed order on 25th September 2023. But thereafter appeal has been preferred. The impugned order in the appeal is.
Yes, I have said that Honorable Division Bench arising out of the order dated passed in this contempt application. 21st March. What is the date? You have a copy of my judgment.
25th September 2023.
25th September 2023.
Yes, ma'am.
In WP numbers, WPA number.
Item number 17, 18, 19 are similar matters.
Being 17, 18, 9 je writ petition number gulo ache na সেগুলো লিখে দেবেন.
Handing a copy of the
judgment.
judgment.
Petitions being WPA number such and such. Specially petitions are pending before the Honorable Supreme Court, and the same is expected to be taken up for hearing sometimes in the month of November 2024. First up, in view thereof, list this matter on December 12, 2024.
My lord, your lordship has recorded special leave petitions, my lord. Only the
diary
number has been assigned because the defect.
But you have preferred special leave petitions.
Yes, ma'am. Yes, yes.
Special leave petitions.
Grateful, your lordship.
I have not mentioned any special leave petition numbers.
Fine.
Yes. 17, 18, 19. Separate orders, but same. Call the next matter.
Twenty টা বার করো, 20 20 এত 19 20 টা দিতে হবে 20
Call the next matter.
20 20
20, I beg to appear on behalf of the petitioner. My lord, on the my lord, this matter pertains to, my lord, non-compliance of an order dated 21st March 2023.
Any appeal preferred?
No. As per my knowledge, there is no appeal pending, my lord.
You
This was
appear for-
taken up twice. This matter was taken up twice, my lord. On the first occasion, my lord was kind enough to direct me service of copy of the, there is 2 orders.
Okay.
There is 2 orders. First is of 22nd August, wherein my lord was kind enough to direct me to serve a copy upon the alleged contemner, which was done. And thereafter on 5th September, when also they could not appear. But my lord, I must point out, they had communicated with me and they assured that they will appear on the next date when the matter will be taken up. But they did not appear on that next date. But the issue, my lord.
I'm keeping at 2 p.m. If you can contact the learned advocate.
My lord, then I may address a letter to again, because I'm not having his phone number right now. It has lost, to be honest. Because that will be the only.
The
My
learned
lord, keep
advocate
it
for the
on
petitioner
Wednesday or
is present. None appears for the alleged contemner. For the ends of justice, the hearing of the matter stands adjourned for the day. The petitioner, the learned advocate on record of the petitioner is directed to communicate the next date of hearing to the learned advocate appearing for the alleged contemner.
কত তারিখে আজকে 4 চিঠিটা করে দিচ্ছি
raw water. Stop. Mr. Samanto, learned advocate appearing for the state, on instruction submits that the said amount, that the same amount was withheld as the treatment plant could not be commissioned on account of non-availability of raw water. Stop. This court has already observed that the neither the municipality in its report in the form of an affidavit nor Mr. Samanto, learned advocate appearing for the state, could point out any deficiency in service on the part of the petitioner in the matter of installation of the water treatment plant as per the tender in question. Stop. The petitioner could not be made to suffer for non-availability of raw water. Full stop. In view thereof, this court directs the chief engineer, municipal engineering department being the second respondent, to issue the written recommendation to the chairman, Boshirat municipality, for release of the amount withheld on the ground of trial run in favor of the petitioner. First up, since the treatment plant could not be commissioned on account of alleged non-availability of raw water, and the petitioner has also claimed refund of the security deposit as well as payment of supplementary bill for idle labor charges / bill for periodic maintenance, the respondents will be at liberty to file a short affidavit with indicating the grounds of objection as against the aforesaid claim made by the petitioner in paragraph 8 of the writ petition in respect of the said amounts. Stop. The second respondent shall issue a written to the recommendation on or before November 11 bola ache to, on or before November 11, 2024. Stop. The chairman of Boshirat municipality is directed to release the amount withheld on account of trial run within a period of 2 weeks from the receipt of written recommendation from the chief engineer, municipal engineering department. First up, it will be open to the said respondent to call for any report or documents from the concerned executive engineer for issuing the letter of for issuing the written recommendation for release of payment. ঠিক আছে, এটা হবে
Grateful, man.
এরপরেই হবে, পরে করবেন। হ্যাঁ, এই লিস্ট দিস ম্যাটার তার আগেটা করবেন এইখানটাতে। ঠিক আছে তারপরে লিস্ট দি ম্যাটার লিস্ট দিস ম্যাটার্স না একটাই তো ম্যাটার
One matter.
লিস্ট দিস ম্যাটার
My one thing, we had prepared a formal affidavit opposing the reports, dealing with the reports. Let that be kept on record. See,
Mr. Sen, you can do one thing because they will be submitting fresh objection.
but
Alright,
let this remain. We'll file affidavit.
He may be served.
We are already
How have you
already.
captioned that?
But here
How have you captioned that? Exceptions or opposition?
no, just opposition because the affidavit.
Alright. The affidavit in opposition
It is formality, just formality.
to the report filed by the respondent number 3
All the three municipalities separate.
is taken on record.
Grateful, man.
I was beseeching one thing, my lord. I intended to produce the NIT or the agreement, whatever may be, on the next occasion, my lord. Kindly record that, my lord. That will.
You produce that along with that if you want
Or
to.
the report, my lord.
Yes, in the short affidavit you can because that is the ground of.
Then draft.
I am grateful.
Yes, call the next matter.
21.
21, I am for the petitioner. My lord, this matter, my lord, relates to pay and allowances as per, my lord, the bench clerk of the district judge Nadia. My lord has already been delivered a judgment. My lord, the identical, same notification.
The Chonde.
My lord, the
Has he come today?
initially, my lord, came, Hussein was engaged. He did not come. Then my lord please to direct me to serve a notice, also petition copy I have also given. One bench clerk, one group D, my lord has delivered a judge.
Yes.
Now these petitioners two bench clerk, same district as Nadia. Even appointment notification
Bring
also
Mr.
same.
Chondi Chorande. Because he was appointed on the last occasion.
Yes.
I'm passing it over.
Yes. বলে দিচ্ছি।
4:15
4:15
or 4
PM
4টের সময় রেখে দিন।
এই দিন তো পরে তখন হবে তখন দেবো।
22.
Well, run for the petitioner. Lordship, in 2013, Lord, in December, Lord, I presented for registration one flat which I purchased from Lord West Bengal Housing Board, who is Lord state. And Lord, question was Lord whether remission on the stamp duty and registration fee on the difference value of Lord set forth value and Lord market value be allowed or not. There is a notification, my lord. In my report,
I could not follow. Set forth value is the value put by you.
My lord,
that has nothing to do.
Yes, this is my lord state.
Stamp duty is assessed on the market price.
My lord, it is my lord here vendor is state, my lord. This is the point, and that is why notification was issued, my lord. And I have annexed that notification by affidavit.
What is your prayer? So any claim, any demand has been raised on account of.
No, my lord. Till
what
that,
is the what have you prayed for?
Initially, they said some documents are required, some information are required. Lordship may see my writ petition.
You have presented a sale deed for registration.
Lordship.
You have presented a sale deed for registration.
Lordship.
You have paid the
as per the assessed value, my lord, I paid.
As per the assessed value means?
My lord, as per my lord, e-assessment. And Lordship see the last order, Lordship directed them to produce, my lord, the e-assessment slip. My lord, which I got, my lord, I submitted along with the deed. And my lord, I did not have any copy, my lord.
Yes,
And that's
produce the query being number 017164.
The difficulty, the only difficulty is this, Lord. The earlier the deeds were used to register under the CORD system, CORD, centralized organized system of registration of documents, CORD.
Yes.
Subsequently, the system got changed by the central government, and it is being registered under the e-nothikaran.
No, this is not query number 017164.
Under the e-nothikaran system, under the change of the system, Lord, the entire query number has changed. The query number
maybe, but on 27th of December 2013, a query was issued.
Yes.
Where is that query?
So that we cannot produce because
Why?
But that was there.
That was issued from your department.
Yes.
Where is that? You must be having records of that. Why can you not produce that records? Look, Mr. Samanto is presented, when a document is presented for registration, previously a query is to be obtained.
Now also.
Mentioning a set forth value. Now it will be assessed what is the market value and the stamp duty as well as the registration charges will be assessed. And in the query, those are to be indicated. That query is valid, I think, for 45 days or 30 days. Whatever.
30 days.
Yes, initially it was for 45 days. If that is presented within that time, that query is subsisting. Beyond that date, a fresh query.
The same number is not telling, but the date of generation.
But Mr. Samanto, the difficulty is that it was presented as per that query. So you must be having that query. How can you now revise that amount?
Not revision, question of revision. That was done under the previous system. The previous query was.
And what is the date of the query when that document was presented?
27/12/2013.
27/12/2013. 27/12/2013 is the date of the query.
Yes, and
where is that query?
This is the query I have. This is the query, but
which you are producing today.
Yes, but
now when the document was presented?
The very next day.
On 28th of December. With this query.
With that query, 27 query.
Now, what is the difficulty now?
The difficulty is this, my lord. They put the amount as per the set forth value.
Set forth value has nothing to do.
Yes, madam. And
set forth value is the valuation put by the. Yes. You have to assess the market value.
You have assessed it.
Yes.
Now the difference amount is due. The difference amount.
Difference from the set forth
and the market value. The set forth is 18 lakhs and the market value is 30 lakhs.
Yes.
The difference is 12 lakhs.
Yes.
Stamp duty upon 12 lakhs is due. This is the difficulty.
Mr. Samanto, there is no assessment on the set forth value. Assessment is only on the market value.
We have assessed it.
Yes.
The difference on 12 lakhs. This is.
Show me the query of 27th of December.
This one. Now the last page, what I have folded, my lord. The last page.
This is a sale deed.
Sale deed. Yes.
What is this last page?
Last page, my lord. This is the query of 2712. Kindly see the, my lord, right hand side top. Last page, my lord. It's in a horizontal form, my lord.
Yes, yes.
27/12/2013. Date of presentation is 28/12.
Yes. Was the registration done on commission?
Yes, my lord. It was commission.
On commission.
So many deeds were commission or registration done on commission. Only this is pending and rest of the deeds has been completed, my lord. Query registration has been completed. Only this one is pending. Total number of 256.
Yes. Now, what is the claim of the petitioner? Yes.
Yes, my lord.
What is your grievance?
I stand at 518 flats are there. All has been completed except this one.
Lord, I have prayed for, my lord, the issue, my lord, the permanent receipt, my lord, which was not done, my lord. Section 52 of the Registration Act says, my lord, when my deed is admitted, my lord, permanent number, with permanent number, receipt is issued, my lord. That is the aim.
How much stamp duty you have paid?
My lord, I paid, my lord. Lordship will find, my lord. See, my lord, their opposition. They have admitted, my lord, and said, my lord, in paragraph in at page 4, my lord, paragraph 5A.
Of their opposition.
Opposition, lordship.
They are respondent numbers 2 and 4.
Lordship.
Yes. Page.
Lord, it page 4, paragraph 5A. May I read, lordship?
Yes.
It is stated that the petitioner had paid the stamp duty and the registration fee amounting to rupees 1,28,278 on 27 December 2013 on the set foot value of the flat. Lord,
Yes.
thereafter, Lord, they are saying not paid on the market value. Lord, I paid as per the Lord, the e-assessment which they have failed to produce. Lord, e-assessment, Lord,
You
obtained
must
by
be having a copy of the query which you have obtained.
Lord,
Where is that copy of the query?
petitioner did not expect such situation would arise. Lord,
No. You must be retaining a copy of the query.
Did not. Lord. He submitted the original with the deed.
Show me your pleading on what value you have paid the stamp duty.
My lord, in my reply, lordship, see.
Yes. How have you
Paragraph,
dealt
Lord,
with
yes,
paragraph 5A in the reply?
My lord, paragraph 4.
Paragraph 5A, how have you dealt with that?
Yes, lord. My lord, in my paragraph 5 of my reply, my lord. My lord, second line. I do not admit the statement made there is 7
So
extra.
according to you, as per this geo, there is a remission which is being allowed.
Lordship.
Where is that geo?
That I have annexed that, my lord, at page 8.
Of the reply?
Yes, my lord, in reply. May I please, my lord, read?
Give me a minute.
May submit, lordship. A writ petition was filed by this various purchaser of this complex, lord.
Yes, Mr. Samanto. What do you have to say on this notification at page 8?
Lord, Honorable Justice Sanjeev Banerjee allowed, my lord.
In
Honorable
case of
Sanjeev
flats-
Banerjee held.
Case of flats, apartments, benefit allowed if the registration has been done within 30th September 11.
Yes.
But this deed was produced for registration in the year 2013.
Let paragraph 2 should read him. He should read paragraph 2 also.
Paragraph 2.
It
I'm
was
reading
done
the-
in 2013. So beyond this date.
Beyond this date.
This date was not, this effect of this notification was not subsequently extended. Are you sure of that?
I have to check it out. But the notification says it will be done within 30th September 11. And the deed was produced on 28/12/2013. 2 years, 2 months. Then I have to take proper instruction whether this was extended or not, Lord.
But this notification was issued in 23rd of March 2012.
Lord, what happened, Lord, at kindly visualize at that point, those point of time, Lord, we used to file the register document with our set forth value. Then there was a assessment by the RA or the ARA or the whatever maybe. After assessment, the difference amount we used to pay. Now, what happened, Lord? Most of the persons keep the deed in a pending number, under the pending number. Nowadays, is no concept of pending number, all will be in the indenture I number.
we used to keep the document under pending number. The documents which have been kept under pending number and the final number has not been allotted, in case of those documents, this was issued.
No, Mr. Samanto, paragraph 2 clarifies.
Yes.
It can be after that, provided they pay interest. So this is extended after that also.
Lordship may kindly consider.
Paragraph 2.
In case of flats or apartments,
Yes.
the benefit is allowed if the registration has been done with the 30th September 11
And
if the
yes.
registration is done on a subsequent date,
Yes.
one per annum stamp duty
Only
chargeable
interest from 1st of October 2011 to the date of registration. This is unending.
to the date of registration.
So date of any registration, any date subsequent to 1st of October 2011. But they are liable to pay interest. That is one thing. But this notification extends to them also.
See, my lord, for the flats and houses which are constructed or to be constructed on a subsequent date, the benefits under this order shall be allowed. This and done within a period of 18 on the date of completion of the certificate issued by the competent authority.
That is neither here. Paragraph 2, they are covered, but they are liable to pay interest only.
But that I have to take, what will be the amount of the interest, my lord, that I have to take instance?
Interest is another thing. They will be liable to pay interest.
Remission also, I may take, my lord, a specific instance.
What you have to submit on first paragraph.
First portion of the paragraph.
What is the set forth value?
Set forth value is 18 lakh. They are set forth value 18
Set
lakh.
forth value by whom?
By them. And the market value is
First paragraph. You consider first paragraph, make your submissions.
where is governor of the reasonable ground for doing so now or comfort and this person of Ireland of the picture. Okay, amount of difference.
There were many flats.
So many flats, my lord.
Similar flats.
Similar flats, my lord, into.
At what rate the other flats were sold?
May submit,
Bring one sample
may
copy of
submit
that
one
document.
judgment, my lord, because in the same premises, my lord.
Yes, it's in
my
the
lord,
same premises.
Yes, my lord. Several flat owners, my lord,
So in the
denied
same
benefit.
premises, Mr. Samanto, other flats were registered at the market value.
Market value. My lord, I have
In the same period.
same period.
What is this?
My lord, in the same premises, my lord, this notification, some flat owners were denied, my lord, benefits were denied. They approached Honorable Court, my lord, the High Court and Honorable Justice Sanjit Banerjee, my lord. Lordship may find the only last page, my lord, page
Here,
8,
who is the vendor?
Yes.
Housing board.
Same, my lord, same premises, my lord, same circumstances, my lord. Their lordship, his lordship held that all flat owners are entitled to benefit of the notification.
Mr. Samanto, be ready with this. Have you seen this judgment? Give him a copy. Acha, look. The learned advocate appearing for the petitioner places reliance upon a decision of a coordinate bench delivered on February 10, 2016 in a batch of writ petitions, the lead case being WP 331 of 2014 within bracket Torun Dixit and another versus State of West Bengal and others. Stop. Mr. Samanto, learned advocate appearing for the state, seeks time to consider the said decision and revert back on the next date. Stop. List this matter. First date diye din. Under the same heading. Sorry. Under the same heading. Next.
Kindly mention the read number with W. Read petition number with W.
I think that is the OTK original side of matter.
No, this is appellate side.
Appellate side. But it has been uploaded in WP.
So, order shows the W.
WP.
WP within bracket W. That WP within bracket W code. Yes, call the next matter.
3. Batch of cases যেটা দিলেন
This is that matter, Mr. Majumdar, Department Promotion Committee issued meeting held, no?
No.
আমরা নেই আছে এই যে আমরা নেই
Matter is ready for hearing.
But,
Affidavits, reports, exceptions, everything
so
complete.
that way is ready for hearing. But my difficulty is somehow my clerk has forgotten to bring my brief. My brief has not come today.
Your brief has not come.
I have got this brief from the solicitor now. His office file has been brought.
It is coming. Let Mr. Mojumdar start because I have forgotten everything. Mr. Gupta, you are otherwise ready.
I was otherwise ready, provided I had the note with me.
Once you go through the papers, everything
But
will
my
come.
note is not with me. But the question is with regard to
So, Mojumdar, how much time it will take?
half an hour. The question is with regard to seniority, or rather restoration of seniority of the writ petitioners. It's with regard to restoration of seniority of the writ petitioners. When the writ petition was filed, they were in E6 grade.
Yes.
They were all in E6 grade.
At the time of
filing the writ petition.
At the time of filing the writ petition. No, at the time of entry.
Oh, they were initially in the non-executive cadre. Now,
Non-executive cadre.
yes, and that is the workmen.
Yes.
Now, the executive cadre begins from E2 grade. Initially, it was E1, now it's E2.
Yes.
But there are two ways of filling up this E2 grade. One is by promotion from the non-executive grade or cadre, and the other is from direct entry or direct recruitment.
So one is by promotion.
One is by promotion and the other is by
non-executive.
Yes.
Another is direct appointment.
Direct appointment or direct recruitment.
You were promoted.
I was a promotee.
On?
Not we had been promoted not some 99 prior to 2000. Prior to
2000.
I'm sorry, 2002. 2002.
Prior to 2002.
No, 2002. 2002.
In 2002. Yes.
Initially, Coal India Limited had a promotion policy which permitted vertical movement. That is, one who obtains a class certificate, he was vertically promoted. Now, this was creating certain anomalies. So, in 2006, the promotion policy got substituted or superseded by a promotion policy which permitted vertical movement only at E2 grade, which was redesignated as E3. And at all other levels, the obtention of certificate in the grade would result in a lateral shifting from second class channel to a first class channel. This is how they designed this. And my grievance in this case is not with regard to all these things. Up to E5 grade, I was senior at all stages vis-a-vis the private respondents. I mean the writ petitioners.
Up to E5 grade.
My lord.
There is no dispute with regard to this fact.
No dispute. E2, E3, E4, E5. And my gradation list at E5 grade also showed me as seniors vis-a-vis the private respondents. But I was senior not only in terms of entry into the grade, but I was also a prior
Yes.
a prior holder of a first class certificate. That's an examination conducted by Director General of Mines and Mine Safety, probably.
First class certificate.
Yes.
Yes.
And the private respondents, they were all along.
Who are for the private? They are
none has appeared. None has appeared.
They are, no one has entered appearance.
None has appeared.
Service complete.
Yes. Twice. It was substitutes.
Yes.
Now,
I think Mr. Gupta will support that.
Yes, not probably.
Because it's actually his decision which resulted
And not, I don't claim not a supersession of their right, really. I only claim parity with them. Now, not
so their rights will not be affected even if
probably. Yes, because the prayers in the writ petition is to promote me on and from the dates on which they had been promoted. Now, the petitioners were holders of second class certificate on a prior date. They were holders of first class certificates on a prior date vis-a-vis the private respondents. Now,
an entry into the cadre was, you are also senior.
But in 2002, that's my pleading, 2002. Now, in 2015, the private respondents
Trouble started in 2015. No.
Trouble started in 2015.
Yes. 2015?
That is more specifically 11th February 2015.
11th February.
Coal India Limited refixed the seniority of private respondents in E5 grade.
Yes.
But this was granted with effect from 5th of February 2007.
5th of February 2007.
And we were promoted to E5 grade in 2010.
So the private respondents were promoted prior to 2010.
They were promoted in 2013.
In 2013.
We were promoted in 2010.
Only one thing. You have said that on 11th of February 2015, Coal India refixed the seniority of
Refixed their seniority.
Yes.
They were initially promoted in 2013 in E5 grade.
Yes.
Now in 2015, their seniority was refixed to bring that at 2007 level. So as on 2015, they became senior to us.
Yes, but with effect from 2007. So practically, they were promoted to E5 in 2007.
Practically.
Otherwise, it could not have been refixed as on that date, giving them seniority.
That's it. So 2015, the refixation order was passed, granting them fixation seniority with effect from 2007. But they were actually promoted in 2013.
Private respondents.
Private respondents.
Yes.
Now in 2017, that more specifically 20th of February 2017.
So now your claim is that your seniority is also to be refixed with effect from 5th of February 2007. And you have to be made senior to the private respondents.
Or at least not, I tell you, Lordship, where the shoe pinches. Not promotion from up to E6 is based on seniority. From E6 to E7, it is more on merit.
All right, you proceed on facts. So after this, what happened?
On 20th of February 2017, the private respondents were promoted in E6 grade.
Yes.
না নেই কোটের জন্য নেই
And you are promoted?
Rider here, they were promoted in E6 grade with effect from 20th of September 2013.
September 2013.
Yes. But I shall place that order.
Only one thing. You said they were actually promoted to E5 in 2013. Can you give the date? Or that is not relevant?
No, I'll just give you, no, that's relevant, page 72. 18th January 2013.
18th January.
My lord.
2013, yes.
Now, 2017, they were granted promotion in E6 grade with effect from 20th of September 2013.
Yes.
But the important line which accompanies the promotion order is, this will take effect from the date their immediate juniors became E6.
From the date
their immediate juniors became E6. Or not at par.
Their immediate juniors practically became effect on.
So whoever was their junior in 2013.
Yes.
And had been granted promotion in 2016.
Yes.
At that time, in 2017, they were granted promotion with effect from that date. That is the date on which their juniors got promoted. So they were given promotion at par with the date on which their juniors got promoted. And that's the language used by Coal India Limited in its order. Now, we made a representation. No, another important fact. On the same date, we were also granted promotion to its E6 grade.
20th February.
20th February 2017.
Yes, with effect from?
Prospectively, but not with retrospective effect.
So it is from 20th of February 2017.
17.
Yes.
Now, our representation got rejected in 2020 by a one-liner. So, we are before your lordships.
Show me that.
Page 122.
Page?
122.
That is the impugned order.
That's the impugned.
Did you make any representation?
I made.
Which page?
But representation, if your lordship kindly comes to page 117.
This was considered
in
hearing given.
Not hearing as such, but not they discarded this at.
Show me 117.
117. So sorry.
Yes.
Grade anomaly created in CIL order of 11th February 2015 during implementation of judgment of Honorable Supreme Court of India. Respected sir, most respectfully, I would like to draw your kind attention towards the grade anomaly created during implementation of judgment of Honorable Supreme Court of India in my seniority in E6 grade in Coal India Limited order number so and so of 2017. In reference to the above said office order, I would like to humbly submit that I am in E6 grade since 20th February 2017, whereas my contemporary Sri Satyendra Singh, Senior Manager Mining, who was promoted with me in E6 grade on 20th February 2017, has been given notional seniority from 20th September 2013, resulting into grade anomaly. I would like to further submit that this anomaly was created in E5 grade when his seniority was given from 5th of February 2007 in compliance to the judgment of Honorable Supreme Court vide letter of so and so of 2015. Synopsis of the case is placed in tabulation hereunder. Dinesh Kumar Singh, Senior Manager Mining, year of passing first class, 5th of August 2004. Please come to the right hand column now.
Yes.
Status of promotion and global seniority position in E2, E3 and E4 grade. In E2 grade, both of us were promoted
You are
against.
comparing with this person.
Yes.
You are comparing yourself with this person.
A comparative table.
Yes.
In E2 grade, both were promoted on 28th of February 2002. In E3 grade, I was promoted with effect from 5/8/2004, while Sri Satyendra was promoted with effect from 15/7/2006, and I was above him in global seniority list. So, my lord, I took birth in a particular grade much prior to this gentleman. Please see the next grade. In E4 grade, both were promoted with a letter of 25/1/2010, and I was above him in global seniority list. In E5 grade, I was promoted on 15th February 2010, while he was promoted on 10/1/2013, and I was above him in global seniority list. Subsequently, after verdict of his case, he was given notional seniority with effect from 5/2/2007, video order dated 11/2/2015, and he was positioned above me in global seniority list, and the anomaly was created.
So this refixation was done pursuant to an order passed by the Honorable Supreme Court.
That's their stand. That's their stand in the report filed pursuant to your lordship's order.
Private respondents were the petitioners or were parties there in before the Honorable Supreme Court.
Probably no, because one Akshay Kumar was a petitioner, which went up to the Honorable Supreme Court.
May not be the petitioners, but they may be in same position or.
In any event, our rights could not have been affected by an order where we are not parties.
Can that be reopened here, Mr. Majumdar?
If had it been between the parties, it would have been a closed issue. But while implementing an order of the court vis-a-vis two warring groups, a group which had already an accrued right cannot be put to a lesser position.
All right.
In E6 grade, both of us got promotion with a letter of 2017, but his notional seniority in E6 grade was fixed with effect from 2013, and he was positioned above me in global seniority list, and the anomaly further continued. Several representations were given against the referred anomaly to your good office enclosed letter so and so. Sir, it is clearly and substantively evident that I was above.
Actually, the trouble started from point number E.
Yes, 2015.
That was with effect from 5th of February
2007.
So that took them above you.
Above.
Yes. So this you have clarified. Now, what is the decision? 122.
122. It's a mere regretting of the representations. We are in receipt of representation for grant of notional seniority with effect from 2013 by comparing their career growth with Satyendra Singh, senior manager. In this regard, this is to inform you that Sri Sarvesh Singh and Dinesh Kumar Singh, upon acquisition of first class mines manager certificate of competency while in E2 grade, got the promotional benefit at the time of promotion from E2 to E3 grade as per the prevalent policy of 2000. Whereas Sri Satyendra Singh, upon acquisition of first class certificate in E3 grade, so admittedly we got this certificate earlier, has availed the promotional benefit at the time of promotion from E3 to E4 grade as per the same prevalent policy dated 22nd of September 2000. Since the promotion in first class channel in mining discipline and consequent seniority is as per policies in vogue at that time, the request for notional seniority in E6 grade cannot be acceded to. Lord, I fail to comprehend not a very meaningful picture being given to the rejection of the representation. But probably what they meant to say is policy prevailing on the date of promotion had to be applied.
Yes.
So the 2000 policy was in operation. So if 2000 policy was in operation, this would also apply to me.
What was the 2000 policy?
Vertical promotion with acquisition of certificates at all grades.
Next, since the placement promotion in the first class channel in seniority is as per the policies, the request for notional seniority Yes. Yes.
Not admitted position is from the date of entry into executive cadre up to E5 grade till 2015. We were all along senior.
Here in the rescind or in the impugned order, it states that it has been admitted that you got FMCC, that is the first class mining certificate, while in E2 grade.
Right.
And they got while in E3 grade, that is subsequently.
Not in any event, not please consider that
has availed the promotion benefit at the time of promotion from E3. So they got this benefit from E3 to E4.
Yes, vertical promotion maybe at that point of time. But they,
as per the prevalent policy of 22nd of September 2000.
2000 policy was substituted in 2006.
Yes.
Now, even in
the end of Coal India is it was done as per the 2000 policy.
Can't be, because they were promoting with effect from 2007.
Yes. Where is the judgment of the Honorable Supreme Court? Has it been disclosed anywhere?
Please come to the affidavit in opposition.
Their affidavit in opposition.
Yes. Now, there is an opposition and there is an additional report. Now, two paragraphs are important from that.
An affidavit in opposition. Yes.
But I need to show to your lordship not the
of
three.
Ongsu Mishro.
Yes.
Page.
Not three judgments one by one. First, the order of the honorable single judge, what the issue was. That's at page 20 of the opposition. Then the division bench order at page 9 and the Supreme Court order at page 18.
Single bench order is at page 20.
20.
Yes. This was affirmed by the Honorable Division Bench. Single bench?
Yes.
Affirmed. So we can take the division bench order.
Not the reason, more the facts and the reasons are in the honorable single judge's order.
All right. Which page you want to place?
Please see note the issue first at page 20.
20, yes.
Grievance as ventilated in the instant application under 226 may briefly be stated as follows.
So who are the writ petitioners?
Yes, please see. The writ petitioners are qualified mining engineers having experience in mining and are employed in various subsidiaries now in grade E3.
Yes.
The services are guided by common coal cadre. We are not concerned with that. Please come to page 22.
22, yes.
Now, this refers to a first class certificate examination, the second line. The result was declared on 15 July 2006. So, the result of the first class examination.
Start from page 21, last paragraph.
Petitioners were all eligible to appear for the first class certificate of competency examination except petitioner number 7 and 8. Others appeared in the said examination, which was held on 19 December 2005. They were confident to be successful. The result was declared on 15 July 2006 and they were declared successful. The first class mines manager certificate of competency was accordingly awarded to them on 15 July 2006 and 20th May 2006 respectively. The petitioners thus became entitled to be promoted to E4 grade with effect from the date of obtaining the said certificate. So, not vertical entry or vertical promotion.
From E3 to E4?
Yes.
Upon obtaining that certificate?
Yes, because not the date was 2006 May, your lordship has got that date, page 21.
Yes.
And the promotion policy was altered on 12th of June 2006. This your lordship will be getting at page 44 of the writ petition.
All right.
The petitioners thus become entitled to be promoted to E4 grade with effect from the date of obtaining the said certificate. The petitioner number 7 and 8 appeared in the said examination in 2004 and successfully cleared in 2005. They, however, did not have requisite experience, and as such, the said certificates were not issued in their favor. This could only be done on 20th May 2006 after they obtained the requisite experience.
So this is with regard to 7 and 8.
Yes. So, but factually, all of them passed the course or obtained that certificate before the promotion policy was altered. Then petitioners were thus entitled to be promoted to E4 grade from the dates as shown in the schedule annexed to the application, because not the policy was at that point of time, whoever passes the certificate becomes eligible to be promoted on and from the date of passing the examination. In that context, the Honorable Court was persuaded to hold that promotion should be given from the date of passing the examination vis-a-vis those petitioners. Schedule annexed to the application, upon promulgation of the promotion policy in the mining discipline, it transpired that some anomalies had cropped up. In order to resolve, a committee was formed. Lordship may skip over not the committee's recommendation. Please see the last 3 lines. The seniority in E4 grade after promotion should be determined on the basis of the suggestions as given by the anomaly committee. As per the said recommendation as well as the rule of 1993, the petitioners were entitled to be promoted to E4 grade with effect from the date when the said certificate was issued to them. In view of the grievances having raised from the various corners, the authority concerned formed anomaly committee. It met on so and so and made certain recommendations in the matter of promotion from lower grade to upper grade on obtaining the first class certificate. As per recommendation, the senior managers on passing first class should horizontally move to first class channel in E3 grade instead of getting promotion to E4 grade. So this was the substituted policy.
This is horizontal.
They created 2 channels. One was the normal channel by reason of seniority, and by reason of the substituted policy, whoever would obtain the certificate on and after E3 grade, he would not be vertically promoted like the earlier policy, but he will be shifted from the normal second class channel of promotion to the first class channel of promotion. Horizontally, meaning thereby in the same grade. Yes. E3 grade to E3 grade, but first class channel.
First class channel in E3 grade.
E3 grade.
So this was the revised policy.
That was the revised.
Yes.
Not pausing here for a moment. Not if there is a change of channel, normally there is a quota fixed. Otherwise, what is the purport of shifting of channels? Not in the judiciary, the examination, the fast track channel of examination. Not one who does not put in that length of service is also entitled to be promoted, but through a fast track manner, but there is a quota of 25%. I'm sorry, 15%. The normal channel is seniority channel, which is 50%. 25 is by direct recruits, and 25% through fast track channel. So whenever there is a fast track channel created, there is always a quota fixation. But Coal India Limited has not fixed a quota for this fast track channel.
So all who will be entitled to will go to the first class channel.
They will be shifted from second class to first class. But not the prime consideration of seniority in a grade is date of birth in that particular grade. If I enter into E4 grade, say in 2006, I am always senior to the person who enters in 2005 or 2006 or on a later date.
But you went to E4 vertically.
Date of entry is prior to those persons.
Now there are 2 channels created.
Right.
So both of you, the petitioners and the private respondents, now belong to different channels.
No, even if it is considered, I had passed first class earlier.
Yes, but now the channel is different.
First class channel. A person who has passed out first class examination has been shifted to first class channel. That's why I was senior all along to these persons in E5.
Yes. No, only one thing clarify. You obtained the first class certificate in E2.
Right. No, I obtained first class
in E2.
Yes, in E3.
In E2.
Right.
So you are vertically promoted to E3.
E3.
At that point of time.
No. I got first class in E3. That's page 36, paragraph pleading is in paragraph 5.
You got first class in
E3.
So you got, at that point of time, there were no two channels.
In 2003, there are no two channels.
So
Right.
you were vertically promoted to
From
E4.
E2 to E3. E2 to E3. No, E2 to E3.
No, so you obtained in E2.
I got in E2, vertically
That's why
promoted
I
in.
said
Oh, I
E2,
see.
you told E3. So you obtained first class certificate in E2. You got vertically promoted to E3. At that point of time, the private respondents were in E2.
E2.
They were promoted subsequently to E3. While in E3, they got this first class certificate.
Right.
Now the promotion policy was changed. So instead of going to E4 vertically, they moved to E3 in first class channel.
Right. By that time, I was E4.
Yes, but you are in vertical, that channel. They moved to first class channel.
I got the benefit of first class once.
Yes.
E2 to E3.
Yes.
They also got the benefit of first class from E3 to E4. I mean E3. Because they were.
The one thing, previously there was only one channel.
Right.
So when you are promoted to E4 from E3 upon obtaining that certificate.
No, I was promoted to E3
from
only.
E2 to E3, you moved vertically.
Right.
They were, while they were in E3, they obtained this first class certificate. Instead of moving vertically to E4, they were shifted horizontally to E3 in a different channel. So both of you are now were on different channels.
Channel remained same because I was a first class obtained.
Same.
Right.
Yes, channel is same. Whoever obtains first class certificate
will be in first class
First
channel.
class channel.
Whoever, whenever.
Yes. So according to you, you were in first class channel prior to them. Yes.
When I passed the examination, that channelization was not there.
Yes.
But with the formation of channel, I was in the channel on a date prior to them.
All right.
At the same grade.
Yes. Now you are placing that judgment. Yes.
Now I was placing not page 21 of the opposition.
No, you are in page 23.
23, I'm sorry.
Yes. Effective first paragraph. In view of.
My lord. Kindly grant me a moment. I lost that page. Yes.
Of the opposition.
Yes, yes.
Effective
in
first
view of grievances being raised from various corners, the authority concerned formed anomaly committee. Not I need not
keep that you start
yes.
from such recommendation was clear.
Yes, such a recommendation was placed before the appropriate authority. It was finally approved by the competent authority. For implementation of such recommendations, respondent number 5 issued an office order of 12 June 2006. Now, that's the change of promotion policy.
This is the new policy.
New policy which permitted vertical movement only at E2 grade. Otherwise, obtention of first class would mean shifting from second class to first class.
Yes.
From the said office memorandum, it could be gathered that the competent authority modified the earlier guidelines in the matter of promotion to the effect that the benefit of promotion on passing first class should be given to only those employees who are working in E2 grade. The executives working in E3, E4 and E5 grade will be horizontally placed in the same grade in first class channel from the effective date of first class. It was decided that such recommendation would come into effect from 8th May 2006. The old cases were left to be decided as per existing norms and guidelines.
Yes.
The petitioners appeared in the examination in December 2005, which is much prior to coming into force of the recommendations of the anomaly committee. Their results were published on 10th June 2006 prior to issuance of the impugned memo of 12th June 2006. Thus, the process of examination and subsequent promotions so far as petitioners are concerned had commenced in the year 2005 as soon as the petitioners submitted their options to appear in the said examination. Under such circumstances, the respondent authorities cannot bring the petitioners under purview of the recommendations, which admittedly came into force after examination process had commenced. It was not right on the part of the authorities to consider the cases of the petitioners according to recommendations of the anomaly committee, when they appeared in the examination, the old rules were governing the field of promotion to the higher grade. This naturally gave rise to legitimate expectation. The authority, by introducing the new policy, has acted in a malafide manner. Petitioners alleged that according to the new circulars, the promotion from E3 to E4 and from E4 to E5 grade on getting first class certificates have been stopped. By giving promotion to 2003, 4 and 5 batches, the respondent authorities have created another anomaly, since the candidates from E2 to E3 shall be placed above the petitioners since they have obtained the first class certificate earlier. But we obtained this earlier, so we would not have been impacted by reason of this judgment at all.
Yes.
Similarly, the candidates in E3 who have not obtained first class certificate have been promoted to E4 on the basis of experience. But the petitioners who are first class certificate holders in E3 grade remained in E3 grade and became junior to those candidates who were in E3 grade in that second class channel.
Yes.
Petitioners claimed that the respondent authorities, having treated the 2003, 4 and 5 batches on a different footing, have acted in violation of Article 14 of the Constitution. The recommendations as contained in memo of 12 June 2006 cannot be made applicable to the cases of the petitioners. Claiming that amending law cannot have any retrospective effect and the process once started should continue to be governed by the existing rules, respondents by such illegal acts have been trying to take away the right existing in favor of the petitioners. So, this was the case of the petitioners.
Yes.
Further submitted that it is mandatory before taking any policy decision to place the recommendations before the board of directors. That is procedural and in no trouble. Please see the stand of the respondents. The last two lines. Respondent contested the case by filing opposition. It is claimed that the petitioners, being the degree holders on being appointed in the post of management trainees in E1 grade in mining engineering discipline, remains on probation for a period of 1 year, and after successful completion of such probation period, they become confirmed in E2 grade. The employees having diploma in mining engineering while working in non-executive position in technical and supervisory grade A and B on possessing second class mines managers on being selected as departmental candidates are appointed to the post of under manager in E3 grade in second class channel after being qualified in the departmental examination. The respondent authorities claimed that the petitioners passed first class in July 2006 and submitted the same in Coal India Limited through their company after changing of the policy of giving so and so. But the guidelines are quoted. I need not trouble your lordship with the guidelines.
Thereafter, the judgments have been considered.
It was claimed that the effective lordship may straightway come to
27.
Page 27, not the paragraph. Please come to the last 4 lines of that page, last 5 lines. The chairman of the committee.
Yes.
The chairman of the committee was further directed to evolve its own modalities for deciding the representations. It was specifically claimed that to remove various anomalies which cropped up consequent upon regulating of career growth of mining engineers on passing first class in terms of earlier policy guidelines which resulted number of litigations, the same had to be reviewed and finally modified to the extent of horizontal placement in place of promotion. The existing guideline, as has been adopted and circulated by Coal India Limited's memorandum of 12 June 2006, was uniformly followed in case of all mining engineers who had passed first class after 8 May 2006, and by implementing the existing guideline, there remains hardly any scope of further anomaly. The existing policy guidelines have been put up to CIL Board of Directors in its meeting of 22nd December. That's procedural. Please come to the next paragraph. The petitioners thereafter filed affidavit in reply claiming therein that the stand of the state respondents is not legally justified. The petitioners claim that the examination for obtaining first class is an integral part of the process for promotion to E4 grade. Such promotional process starts on the date of advertisement is issued inviting applications from the eligible employees. On the basis of an advertisement issued in the month of September 2005, the petitioners applied for allowing them to sit for the examination for promotion. They submitted their applications within 17th October 2005 and appeared in the examination which was held in December 2005. On 12 June 2006, result of the written examination was declared. Only the employees who completed requisite number of years in their respective posts from E2 to E4 were eligible to sit for the said examination for promotion. after successful completion of the said examination, the candidates were to get on promotion from their respective feeder post. The petitioners claimed that the notification dated 12 June 2006 is arbitrary and prejudicial to the petitioners. Petitioners appeared on the basis of the provisions laid down in the rules, which were subsequently amended, and as such, their fate was to be decided by the old rules. Petitioners further claimed that there are no other candidates who would be prejudicially affected, as there are no other candidates who sat for the examination and were declared passed on the basis of the old rules. On 26 November 2007, a memo was issued by the Chief General Manager. By the said memo, the petitioners along with others were horizontally placed from second class to first class channel on their passing and submission of first class certificate. It was categorically stated that most of the petitioners passed the first class examination on 10 June 2006, which is prior to the issuance of the office memorandum of 12 June 2006. Their certificates were withheld by the authorities and were issued only after issuance of the impugned memorandum. The petitioner number 7 and 8 passed the first class examination in 2005, but certificates were issued to them in May and July 2006 respectively. It was alleged that the guidelines as mentioned in the paragraph under reference are discriminatory so far as the petitioners are concerned, as it has sought to treat the petitioners on a different footing from the other candidates who also passed the written examination before 12 June 2006. It was claimed that the effective date of passing as shown in the certificate is the sole determining factor. The date of initiation of the examination process and taking part in such examination of the employees for their respective promotion are the determining factors for giving vertical promotion to the employees.
Only one thing, these private respondents, they obtained first class certificate when?
They were, paragraph 6, I have stated.
Prior to that June 2006 or after that?
But I have mentioned 2006.
But the date may be relevant.
Please come to paragraph 6.
Because if you come to page 36, the concluding, the decision part of that judgment. So the issue was, they are the writ petitioners.
Yes.
They appeared in that examination prior to 12th of June 2006. So that is why the coordinate bench
court held that since the process had
not horizontally, so they have to be moved vertically.
Since they had already participated in an exercise prior to
2003, 4 and 5
right,
batches.
right. Now please come to.
So now when these private respondents obtain this first class certificate.
Yes, please come to page 35 of my writ petition.
Give me the dates. Whether it is prior to June 2006 or after that.
Some of them, one of them is prior to that effective date of policy. Others are post that date.
So, in terms, if this judgment is applied, one who was prior to 12th of June 2006 would move vertically to E4.
E4.
Others will move horizontally to E3.
Now, all of them having been granted promotion.
Now, this was affirmed by the Supreme Court. No change.
No change. In principle, no change I would submit, because I just cursorily take your lordship through the part of the orders. Please come to page 9. That is the division bench order of the self-same affidavit.
Division bench have affirmed.
Yes.
Special petition is also dismissed.
Dismissed. Please come to page 12 of the opposition. The second paragraph, the writ petitioners have challenged the memo of 2006 by which the recommendations were to be implemented with retrospective effect. Please turn over to the next page. There's the submission recorded. Now,
you can come to page 19 of
effective part is 18 and 19.
Page 19.
Yes.
As the process of selection started prior to 8th of May 2006.
Right.
The date on which the subsequent policy decision had come into effect, and in view of the judge's bench, refused to interfere.
Principle is no.
So, yes. So that is the effective date. If the selection process started prior to that, so according to you, in respect of one of the private respondent, it was prior to that date.
That's page 35. Not I,
So
the
this
undisputed chart.
judgment is applied. Only one of the private respondents would move vertically to E4.
E4.
And the others will move horizontally to E3.
E3. Please come to page 35.
That is your submission.
Yes. Please come to page 35 once for a cursory glance
35
of the writ petition.
Yes. This is the private respondent's
Yes.
promotion chart.
My lord.
Yes.
Now, please take note the just after that effectiveness of first class certificate. Note, unfortunately, this caption is missing on the next page. The previous page contains that caption.
Yes, effectiveness of FCMC.
Yes, that's
this column.
Yes.
So this is 7th of June 2006.
Yes, that's before 12th of June 2006.
Yes.
That's the date of.
But after 8th of May 2006.
After 8th of May.
The Honorable Supreme Court's judgment is process is
but effective date is the date on which the
as the process of selection started prior to 8th of May 2006.
That was vis-a-vis the petitioners, but not principally the date of passing the first class examination is the effective
relevant date.
So the date of passing the examination is 7th June 2006.
That is prior to 12th of June.
12th of June.
So first, the private respondent
Only one
in that chart is number 1.
Yes.
All the others were
15th July and one is 9th December.
So all of them were given vertical promotion
with retrospective effect in E5 grade.
They were in E4 at that point of time.
That was redesignated as E5.
Yes.
But not keeping all things apart. I mean the petitioners were an earlier entrant in a grade.
Yes.
And the concept of seniority is grade seniority. That's why a seniority list is often called a gradation list. Seniority is reckonable to a particular grade. One might have entered into service on an anterior date, on a much earlier date.
Yes. Yes.
But grade seniority is reckonable with the date of entry into the grade. If the petitioners had been earlier entrants in a grade and they had received the benefit of this early entry by reason of their normal channel of promotion now, having been moved into the first class channel as well, thereafter it is only normal channel. Not according to me, in my most respectful submission, what your lordship will ultimately hold. Not this segregation into two channels is meaningless unless you have a quota for fast track channel.
Yes.
But I both now belong to a channel, a grade, second class channel, first class channel. Who is to be reckoned as senior? Who has entered into the grade earlier?
So according to them, they have refixed on the basis of this judgment of the Honorable Supreme Court.
Now, please visualize the situation. After 2006, two employees are working side by side in E4 grade.
Yes.
One in second class channel, the other in first class channel. The second class channel entrant has a length of service of say 5 years in E4 grade. The other has say 3 years service, which is the requisite length of service for promotion to the next rank or grade. Now, who will be promoted earlier? Certainly not the first class channel person, because the second class channel entrant is the earlier entrant, and the in gradation list is superior.
Senior.
So senior. So unless Coal India Limited creates a separate channel or quota for these first class entrants, first class examinees, not this shifting from second class to first class is meaningless.
Yes.
Now, please come not to the explanation given. Not the opposition probably does not deal with the situation clearly. After your lordship had invited a further report from Coal India Limited, they have filed a report. কিছু শুনছো না বোধহয় বা কিছু বুঝতে পারছো না please come to page 8 of that report.
Yes.
Now, this has a broad caption in C, career growth of private respondent.
Yes.
All 10 private respondents were also initially appointed in non-executive cadre, and upon passing SMCC, that is second class mines manager certificate of competence, they were also selected or promoted from non-executive to executive cadre in E2 grade in mining 2 channel CL channel in 2002. Having not
second class channel.
Yes, should be mining second class channel.
Yes.
That's a normal channel. Having not acquired FMCC while working in E2 grade, they were not placed in E3 grade of mining first class channel as per para AG11 above. As per para AF, since all private respondents did not acquire first class certificate while working in E2 grade, they were all promoted to E3 grade in second class channel under time bound cluster concept of promotion on completion of minimum residency period of 3 years with effect from 30th
That is
September
automatic
2005
promotion upon completion of
of
that.
a residency period of service.
Yes.
While working in E3 mining second class channel, all private respondents have acquired FMCC with effective dates after 8th May 2006. That is, acquired FMCC after the mining policy dated 12th June 2006 came into effect.
So that is a clear admission. Yes.
If the ratio of the judgment is employed in this case, then they cannot steal a march over us.
Yes.
In terms of the policy dated 12th June 2006, all private respondents were horizontally placed in mining first class channel with effect from the effective date of first class channel with the orders of 26th of November 2007. Copy annexed. At this juncture, Sri A.K. Jana and 23 others, not the judgment which I was placing from the opposition, Akshay Kumar Jena and 23 others, which includes private respondent numbers 5 and 7, so 2 of them were petitioners, who were horizontally placed from second class to first class channel in their existing E3 grade from the effective date of first class mines manager certificate. Alike all private respondents have filed a writ petition before the High Court praying for promotion to E4 grade in terms of earlier policy dated 22nd of September 2000.
A.K. Jana and 20, which includes the private respondent numbers 5 and 7, who were horizontally placed from in their existing from the filed writ petition. So 2 of the private respondents were the writ petitioners.
It appears. But not please see with paragraph D. When your lordship is considering the judgment in A.K. Jana's case, your lordship is also considering paragraph D.
But Mr. Mujumdar, that cannot be gone into because their cases were considered. If they were the writ petitioners,
very well,
they have been granted relief.
2.
They have been granted relief.
2. Now, what was the ultimate judgment of the court? Court said you can't apply a policy for them, which was not existing at the time of taking the examination.
But the operative part says all the petitioners were
to be treated.
promoted.
Please see page 27, 29 probably. I'm sorry, page 30.
All right, you complete this, thereafter we can shift over to that.
There is, please come to page 36 of the, I just read it for your lordship's consideration.
Yes.
The respondents are directed not to give effect to the memorandum of 12 June 2006 to the writ application so far as the claim of the present petitioners are concerned. Correct.
So all these, so they are covered.
The said authorities are directed to promote the petitioners to
Yes.
E4 grade from E3 grade in the first class channel with effect from the date mentioned in their first class certificate by treating them at par with 2003, 4 and 5 batches. So with effect from the date on which they passed. That was the direction. And paragraph D says.
So passing is on 2007.
2006.
No, void orders dated 26/11/2007. Paragraph E.
In terms of the policy, the respondents were horizontally placed in the first class channel.
On 26th of November 2007.
Placed in the first class channel.
Yes.
A copy is annexed as marked as so and so. At this juncture, Ekejana and 23 others filed a writ petition. Not I have shown to your lordship not what the writ petition directed. But it's only depicting the flow of the case up to the Honorable Supreme Court. In compliance of the said judgment, 64 similarly placed executives, including private respondents, have been given notional benefit in a revised E5 grade with effect from 5/2/2007. Please compare paragraph D on page 9 with paragraph G.
If they were after 2006, the earlier policy could not have been given effect.
Given effect to.
So this is the dispute.
Yes, sir.
You want to cite any decisions on this?
Just two more paragraphs from that affidavit.
This report?
From this, yes, report.
Yes.
Please come to page 11 straightway.
Yes.
Paragraph D, reason for variation in seniority amongst private respondents and petitioners. That's the caption.
Yes.
As explained in para C, F and G above, on Honorable Supreme Court judgment in Ekejana case, all the private respondents have been considered for promotion to E4 grade of mining first class channel as per policy of 2000 instead of horizontal movement in erstwhile E3 grade of mining first class channel with effect from first class certificate effective date as per policy dated 12 June 2006. The above promotional benefit from erstwhile E3 to erstwhile E4 benefit was administered not only to the batch of private respondents but also to their earlier batches who have acquired FMCC prior to 2006 while working in E3 grade in terms of policy dated 22nd September 2000. So if a direction of the Honorable Supreme Court or a result of a litigation which binds the writ petitioners only or not grants benefit to a batch of petitioners only has been applied across the board for all persons, then why should these persons, being the writ petitioners in this instant writ petition before your lordship, would have to await the outcome of some same treatment? Though the private respondents, please see paragraph C, though the private respondents were juniors and acquired FMCC after petitioners, they were given due promotion benefit of FMCC to erstwhile E4 grade as per the prevailing policy dated.
These two are the admitted position. You obtained FMCC prior to them, and they were the juniors. These two are admitted.
Admitted position. Now, what could be the only intelligible factor in this case was a quota for this first class promotees.
The issue is whether the policy of 22nd of September 2000 would have been given effect to in case of the private respondents. When their FMCC is after 12th of June 2006.
Number one. Number two, we were born in the grade much earlier to them. We had taken birth in the grade already.
Want to cite
Yes,
any
two
decision?
citations, two judgments.
You want to show anything from these documents?
No,
or
just that report I.
want to
Yes, there is a chart in the report which I wanted to show.
yes. Page.
Please come to page 24. No, this is their document.
24
of that self-same report. There is a chart.
Yes.
Now, this is for the petitioners.
This is for the petitioners. Yes.
Please see the first class date. The extreme right hand column is the first class date.
Yes, certificate date.
That's the first class date.
Yes.
13th August 2004.
Yes.
Gradation list E6 to E7 13 2022, E5 to E6 2017, E5 2010, E4 13th August 2004.
Yes.
It goes on like this. Not some have had acquired this in 2002 even. 2002 and March 2005. So these are the 16 petitioners.
So these petitioners were prior to those June
2006.
So they were under the old policy.
And not grade wise, the dates for grade wise horizontal vertical movement has also been given in this chart. Please see the first petitioner, Madhusudan Singh.
Ravindra.
Madhusudan Singh, the first petitioner.
Madhusudan Singh, yes.
The last entry in the penultimate column, E2.
Yes.
So he was born in E2 grade on 28th of February 2002.
Yes.
Then he was normally promoted to E3, 13th of August 2004.
No.
By reason of that first class certificate.
Yes.
First class certificate.
Yes. This is vertical at that point of time.
Yes. Vertical.
The old policy.
Right. E2 to E3. E3 was redesignated as E4. So that's why E3, E4 written like that.
Yes.
Then E4, E5, 15th of February 2010.
Then it goes on. That is.
It goes on like
yes.
Normal promotion.
Yes.
Now please come to page 31.
31.
My lord.
Yes.
Please see the caption. Executives who got notional seniority benefit in E5 grade as per Honorable Supreme Court judgment Akshay Kumar Jena.
Yes.
Please come to page 33, serial 31.
33.
My lord.
Serial 31, yes.
Mohesh Prasad, his respondent number 4.
Yes.
Mining first class holder. Has your lordship got that column?
Yes.
Serial 31.
So he would get this because he obtained on 7th of June, prior to 12th of June.
You see, P deemed date, that is promotion deemed date. The caption of that column. At the top, P deemed date.
Yes, 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 yes. That is 1st of March 2022.
Yes. That's the deemed date of promotion to E7.
Yes.
Because he has been reckoned to have obtained this first class on 7th June 2006.
So he got vertical promotion to E4 from E3.
Now,
yes, there is no dispute because he passed
only one.
Yes.
Take any other page
so
30.
for the others.
Please see serial number 14, Satyendra Singh.
14.
My lord, page 32.
Yes.
Satyendra Singh is one instance.
So according to you, he could not have been promoted to E4.
15 July 2006.
Have been given horizontal to E3. Yes.
Then please see Akshay Kumar Jena.
So These
Petitioner.
are- So according to you, this benefit has been given to all. Your submission is that, Mr. Mujumdar, all were given vertical promotion in spite of the fact that they obtained FMCC after 12th of June 2006.
I can certainly show to your lordship, Lord, they have acted contrary to the court's order. Even, please come to the case of Akshay Kumar Jena at page 33.
Akshay Kumar Jena.
Yes. But the court directed to treat them under the old policy.
Yes.
15th July 2006, serial number 33.
Serial number 33, yes.
His effective date of first class is 15th July 2006.
Yes, because he obtained 15th July 2006. That was the effective date of FMCC.
But the policy was 12th June.
Yes, 12th June. So, so he would have got the benefit of horizontal, not vertical. Yes, that is what
page 11
who obtained FMCC
after
12th of June, they were given vertical promotion instead of horizontal promotion.
So that if page 11 of the report is to be reconciled with the judgment of the court, of the coordinate bench, which has been upheld by the Honorable Supreme Court even, the only meaningful reading which it may infer into is the petitioners in this case cannot be allowed to be sufferers by reason of a faulty action.
Or in the other way, the cutoff date is of 12th of June. Those who got earlier, they could have been given vertical promotion after horizontal promotion. That is the sum and substance of the reading of the order according to you.
My lord. And the court, in the ordering part, in the decretal part, or the ordering part, said you apply the promotion policy of 2000 for those who have passed earlier.
Yes. So that is vertical. Vertical only to those.
To those. Now, on admission in the report, even they show that this Akshay Kumar Jina and some other persons who are private respondents herein have obtained the certificate. The effective date of certificate is subsequent to the date of the policy.
Yes. What are the decisions you want? Anything more from this?
No. I just have to show to your lordship the relief that needs to be addressed to. Not what happens as of date now. With the passage of time, we have now been born in E7 grade. Now, what could be the remedy made available to the writ petitioners? Please come to my exception, paragraph 7. Paragraph 7 and 8. It is an exception filed by Madhusudan Singh, affirmed on a very short one.
Paragraph 7, yes.
I say that seniority is an important factor in all promotional exercise for E5 to E6 and E6 to E7 grades. All the writ petitioners except the petition number 14 since deceased are in E7 grade. But when we filed the writ petition, we were in E6 grade. By the passage of time, we are in E7 grade now. Such promotion has been effected in 2022.
Mr. Mujumdar, petition number 14 has been substituted.
No, not he has expired. He has not been.
But legal heirs are entitled to this benefit.
But they have not come.
Yes.
If the respondent company would have refixed the seniority of the petitioners with retrospective effect, alike the private respondents, then each of the writ petitioners would have been eligible to be considered for promotion to E7 grade in 2019, 20, 21, and 22. Not this, I have shown to your lordship not the stand in that report wherein they say that while applying the Honorable Supreme Court's judgment, they considered everybody, not only the writ petitioners, the persons involved in that case. Each of the writ petitioners would have come within the zone of consideration by weightage of seniority given on their respective refixation on and from the dates on which the private respondents have become senior to the writ petitioners. Not this has got three components. One is seniority, one is ACR, the other is qualification. Now, these three sections carry certain weightage or marks.
This review DPC, what we have prayed for, according to you, you ought to have been considered from a retrospective
2019,
date.
because I would have come within the zone of
So
consideration.
is this review DPC permissible?
Of course, yes. No, that's the review DPC is held from 1989 onwards. It's for PSCs. And that's the office memorandum of Government of India for all DPSCs. For the purpose of evaluating the candidature of the writ petitioners vis-a-vis those in.
So that is your relief which you are now seeking. With retrospective effect, constitute a review DPC, consider
Give us
our
our
case.
due weightage by giving a retrospective refixation of seniority. If we come, if we are promoted, give us from the date on which the juniors had been promoted.
Yes. Anything more?
Please come to paragraph 8.
8, yes.
The writ petitioner's notional seniority in E5 grade should be fixed from 5 to 2007 and in E6 grade should be fixed from 20th of September 2013. But that's the date from which the immediate juniors have got the benefit. These are the dates on which the writ petitioner's juniors, that is the 10 private respondents, got promoted in E5 and E6 grades based on the principle of seniority cum merit. It is stated that only for promotion from the rank of E6 to E7, the promotion is based on principle of merit cum seniority. Therefore, refixation of seniority of the writ petitioners in E5 and E6 grades does not require constitution of review DPC. Now, just to show that the same has been followed by Coal India Limited in its own orders earlier, please come to page 102 of the writ petition. When in 2017 they were granted the retrospective seniority in E6 grade.
107.
102 of the writ petition.
Yes.
The following manager mining first class in E5 grade are hereby promoted to the post of senior manager in E6 grade in the scale of so and so and posted as such in the existing company as indicated against their name. Please come to serial number 3.
Yes.
Mahesh Prasad, he is respondent number 4.
Yes.
Please come to serial number 27. Satyendra Singh, he is respondent number 5.
Mahesh Prasad is respondent number
4.
Yes.
27 is respondent number 5.
Yes.
Serial number 54 is respondent number 6. But 54 to 60, they are respondent number 6 to 12.
54 to 60. Respondent numbers
6 to 12.
Yes.
64 is 13.
Yes.
And where the petitioners come from, serial number 67 onwards.
Yes.
Now please come to 105. The penultimate paragraph. Serial numbers 2 to 64 will get notional seniority and notional fixation with effect from 20th September 2013 at par with their immediate juniors. However, the actual financial benefit shall accrue to him only from the date of assumption of charge of the promoted post.
So that is notional seniority and notional fixation.
With effect from the date on which the juniors had been granted the relief.
Yes.
And just to show that not we were senior to them in E5 grade in 2010, please come to page 71.
Yes.
Petitioners were promoted in 2010 in E5 grade.
Yes.
Now please come to page 72. 18 January 2013. And these are the promotion orders for all the private respondents.
Yes. Yes.
the decisions 2013 8 SCC 693. Copy that. I copied it down.
693.
13 8 is either Asha or me. Then sit down. 13 8 SCC 693.
Yes. Paragraph.
Not paragraphs 45 and 46.
Yes.
And I just not place it and then hand up. But I'm sorry, not this judgment doesn't have a second copy.
Place the paragraph.
Without intending to multiply precedents on this subject, reference may be made to a decision rendered by this court more than 2 decades ago. In State of Bihar versus Akhauri Sachindra Nath, it was held that retrospective seniority cannot be given to an employee from a date when he was not even born in the cadre. So also, seniority cannot be given with retrospective effect so as to adversely affect others. But it adversely affects me. Seniority amongst members of the same grade must be counted from the date of their initial entry into the grade. In the instant case, I skip over that affidavit portion. The decision was cited with approval a few years ago along with the decision in Keshav Chandra Joshi. This court held that when a quota is provided for, then the seniority of the employee would be reckoned from the date when the vacancy arises in his or her quota and not from any anterior date of promotion or subsequent to date of promotion. Now, that's why I had been repeatedly stressing on this creation of quota for the first class channel entrants. Otherwise, not the basic concept of seniority, which is a civil right of an employee, is completely demolished. In the same grade of E5, a second class channel entrant and a first class channel entrant enjoys the same status. Unless there is a preferential right created in favor of the first class entrant or the first class examinee to a quota created, like not first class fast track examination in the judicial service. It was observed that injustice ought not to be done to one set of employees in order to do justice to another set. It was said in Uttaranchal Forest Rangers case and so that when promotion is outside the quota, seniority would be reckoned from the date of the vacancy within the quota rendering the previous service fortuitous.
If there is a quota.
If there is a quota. And the next citation is 2011 3 SCC 267. 267.
Yes. Paragraph.
Please come to paragraph 45.
Yes.
From the above, the legal position with regard to determination of seniority in service can be summarized as follows.
Yes.
1. The effective date of selection has to be understood in the context of the service rules under which the appointment is made. It may mean the date on which the process of selection starts with issuance of advertisement or the factum of preparation of the select list, as the case may be. Inter se seniority in a particular service has to be determined as per the service rules. The date of entry in a particular service or the date of substantive appointment is the safest criterion for fixing seniority inter se between one officer or the other, or between one group of officers and the other recruited from different sources. Any departure therefrom in the statutory rules, executive instructions or otherwise must be consistent with the requirements of Articles 14 and 16. Ordinarily, notional seniority may not be granted from the back date, and if it is done, it must be based on objective considerations and on a valid classification and must be traceable to the statutory rules. The seniority cannot be reckoned from the date of occurrence of the vacancy and cannot be given retrospectively unless it is so expressly provided by the relevant service rules. It is so because seniority cannot be given on retrospective basis when an employee has not even been born in the cadre, and by doing so, it may adversely affect the employees who have been appointed validly in the meantime. Now, please come to 63.
63. Yes.
To the decisions referred to on this point in the main judgment, I may add just one more. In Suraj Prakash Gupta versus so and so, the decision relates to a dispute of seniority between direct recruits and promotees, but in that case, the court considered the question of antedating the date of recruitment on the ground that the vacancy against which the appointment was made had arisen long ago. In SCC para 18 of the decision, the court framed one of the points arising for consideration in the case as follows: whether the direct recruits could claim a retrospective date of recruitment from the date on which the post in direct recruitment was available, even though the direct recruit was not appointed by that date and was appointed long thereafter. The court answered the question in the following terms: direct recruits cannot claim appointment from the date of vacancy in quota before their selection. We have next to refer to one other contention raised by the respondent direct recruits. They claim that the direct recruitment appointment can be antedated from the date of occurrence of a vacancy in the direct recruitment quota, even if on that date the said person was not directly recruited. It was submitted that if the promotees occupied the quota belonging to direct recruits, they had to be pushed down whenever direct recruitment was made. Once they were so pushed down, even if the direct recruit came later, he should be put in the direct recruit slot from the date on which such a slot was available under the direct recruitment quota. This contention, in our view, cannot be accepted. The reason as to why this argument is wrong is that in service jurisprudence, a direct recruit can claim seniority only from the date of his regular appointment. He cannot claim seniority from a date when he was not born in the service. But factually, we were born in the service, say in E5 grade since 2013. Or I'm sorry, 2010.
Yes. Anything more?
Just not a judgment, not exactly in this same factual scenario, but a coordinate bench was considering not the issue of seniority not of other candidates in the anvil of obtention of first class certificate. এটা দেখি নীরজ কুমারটা দেখি আরে কিছুই আনোনি তো ঝামেলা করতে এসছো কেন
Unreported.
Yes, not
you have to give a copy.
It was, but they were the architects of this judgment, not so.
Yes.
But I have just marked the paragraphs, which are 8, 9, 10, and 13 to 22.
Give the repetition number or the
WPA 25594 of 2018. 25594 of 2018.
Yes, paragraph.
Not 8, 9, 10.
Page 9, 10.
Paragraphs 8, 9, 10. Not, I just placed the paragraphs.
Yes.
It has been submitted on behalf of the respondents, that Coal India, that indisputably 4 petitioners obtained first class in 2003, whereas 3 mine officers, namely Miraj Ahmed, Anish Ahmed, and Uday Raju, obtained first class in 1994 to 95. And as such, as per the policy of 2000 in E5 grade, those 3 candidates are to be treated senior to the petitioners. That was the 2000 policy. According to the respondents, these 4 petitioners obtained first class on 20th July 2003, but were shifted to first class channel and promoted to E6 grade with the order of 2004. Whereas 3 other candidates, namely Miraj and so, were shifted to first class and promoted to erstwhile E4 grade in the year 1999. Albeit, they acquired qualification in 94-95. So they passed first class in 94-95. It has further been contended on behalf of the respondents that some aggrieved executives filed a writ petition in 2009, Kumar Narendra, not where the court held, not I have enclosed that judgment in the opposition, wherein the court held that first class holders of certificates cannot be made to suffer, and those who are holders of first class certificates on an anterior date, they should always be promoted earlier. And seniority cannot be broken at different stages of service. Of course, that has to be read in the context of grade seniority, meaning thereby in the same grade. In the said writ petition, a coordinate bench delivered judgment in 2013 directing the benefit of promotion to be given from the date of passing the first class certificate. Pursuant to such directions as contained in the judgment, the writ petitioners video order of 2017 were notionally granted seniority and fixed in E6 grade with effect from 2003 instead of 2004. So the effective date of promotion was the first class obtention of certificate. It has been submitted by Mr. Gupta that petitioners got the full benefit of judgment in Kumar Narendra by grant of notional seniority and notional fixation in E6 grade with effect from 2003 being the date of obtaining first class certificate, whereas those three mine officers, though obtained first class in 1994-95 and in spite of their entry into E5 grade in 1999, could not be allowed full benefit of the judgment of Kumar Narendra. It has also been pointed out that in April 2009, when the DPC was considering promotion of executives, the petitioners as well as those three mine officers were in E6 grade. Those three mine officers in 2009 were senior to the petitioners in E6 grade, since the petitioners at that point of time had seniority in E6 grade with effect from 2004. Paragraph 13. Another limb of submission made on behalf of the respondents is grant of retrospective promotion to E7 grade with effect from 28 July 2009, as claimed by the petitioners, will lead to filing of similar other cases which would render the situation topsy-turvy in fixation of seniority of mining executives. Now, I placed before your lordship page 105 of the writ petition. And this was applied across the board. And not that page 11 of the report, wherein they said that they applied the judgment not only for the petitioners in that cases, but for all. So this question or argument will not fortify the stand of Coal India Limited in this case. While balancing two lines of submissions made on behalf of the respective parties, this court is tasked to apprise the claim of the petitioners for grant of notional benefits with effect from 28 July 2009. In taking note of submission made on behalf of the respondent authorities, it appears that those three mining executives who obtained first class in 94-95, whereas the petitioners obtained first class in 2003. Not in this case, not we obtained the first class earlier. There is no denying fact that those three mining executives were promoted to E5 grade in the month of November 99, whereas petitioners were promoted to E5 in December 2000. In that case, they are later on promoted. According to the respondents in E5 grade, those three mining executives were senior to the petitioners and they obtained first class certificate, whereas the petitioners obtained first class in 2003. In the aforesaid backdrop, claim of the petitioners for either promoting them to E7 grade with effect from 2009 or to grant notional benefits for E7 grade in 2009 needs to be examined. The chronology of facts reveals those three mining executives were senior to the petitioners in 2009 when DPC was considering the promotion of the executives from E6 to E7 grade. Since the petitioners at that juncture was found to be born in E6 grade on 27 September 2004, whereas those three executives were in the same should be grade, not cadre, with effect from 30th September 2003, which led the said departmental promotion committee to recommend in favor of the three mining executives to promote them from E6 to E7 grade. On the contrary, petitioners were granted notional seniority and notional fixation with a 2017 order with effect from 2003. As per the order of 2017, notional seniority and notional fixation in E6 grade was accorded to the petitioners in terms of the decision of Kumar Narendra, which is also the very basis of claim of the petitioners. It is fortuitous circumstance so far as the petitioners are concerned, who were accorded notional benefits and notional fixation in E6 grade with the order of 2017 with effect from 23, albeit originally they were promoted to E6 grade with effect from 2004. With the order of 2004 on acquiring first class certificate in 2003 upon placing them in first class channel. Therefore, from 27th September 2004 till grant of notional seniority and notional fixation with effect from 2003 in E6 grade with the order of 2017, petitioners did not raise any demur against such arrangements. The aforesaid inter se seniority of the petitioners and those three mining executives in E5 grade on the anvil of promotional policy of 2000 cannot be brushed aside while considering the claim of the petitioners for promoting them from E6 to E7 grade or to grant notional benefits thereof, as it has been pointed out previously that it is the fortuitous circumstances under which petitioners approximately 13 years after being promoted to E6 grade got the benefits of notional seniority. In Sudhakar Rao, the apex court, while considering inter se seniority of two groups, members of one group were upgraded from supervisors to junior engineers on acquiring engineering degree, and members of other groups were direct recruits with engineering degree, wherein it was held seniority of members of one group cannot be reckoned from the date when those members were not born in the cadre, thereby impacting seniority of eligible members of other group. In this context, it was decided by the apex court that seniority amongst members of the same group must be counted from the date of their initial entry to the grade. So, but ultimately, the court held that the decision taken by the respondents in the present case does not reveal a situation that an attempt has been made to attribute seniority to those three mining executives from a date when they were not even born in the cadre, because that old policy was applied for them prior to 2000. They passed in 94-95. Therefore, they were granted a refixed seniority with retrospective effect. And the cases of the petitioners in that case, in this other case by the coordinate bench, it failed.
Yes. Give a copy or the reference to Mr. Gupta.
No, no. Wait, Viraj Kumar.
Yes.
No, these are the submissions.
Yes, Mr. Gupta.
In my humble submission, this is not a case directly on the aspect of seniority. Seniority, my lord, is an issue which is consequential, but the case is not on that. The case is on the applicability of the 2000 or 2006 promotion policy. Nothing beyond that. Seniority is a consequence.
It has been refixed. Your stand is that you have refixed the seniority in terms of the Honorable Supreme Court's decision.
My lord, the Coal India has to fight the same cause in two different proceedings. One, the previous one which went up to the Supreme Court, and now the present one on the same cause of action. My lord, our stand consistently in the previous case was what my learned friend is contending today. That promotion in vertical promotion will be given only on the basis of the date of acquiring the first class mine manager certificate. This has been our consistent case all throughout. My lord, the learned single judge, my lord, made some observations which have two different meanings. I shall show that to your lordship. That's a single bench judgment. Therefore, my lord, the Coal India had to move the division bench. But in the division bench, my lord, the basis on which our policy of making a vertical promotion as in 2002 is not to be applied in 2006 scenario, where the employee had obtained the FMCC first class certificate after 12 June 2006. This is our policy. The division bench and the Honorable Supreme Court did not accept this. According to the division bench as well as the Honorable Supreme Court, the division bench went more in more depth into the matter. The basis is that once the selection process starts, any amendment to an existing rule will not apply to those cases. This is my lord what the division bench holds. Here, what is the selection process here? The division bench holds on this that the selection process in respect of promotion and conversion from one channel to the other, it depends on
Acquisition of a certificate.
acquisition of a certificate or not certificate. It depends on a particular examination.
Passing of an examination.
I'll not say passing. Depends on a particular examination. Why I try to make this distinction? Because the Supreme Court says, and I start with division bench. The division bench says that it is not the date of passing the examination, but the date when the selection process, which is integral to a promotion, starts. Now, when does it start? It starts with the written examination for FMCC. FMCC examination, the result may be out in May 2006 or later. Result may be out beyond 12 June 2012, 2006. But if the written examination for FMCC starts before that date, that gives the starting point for choosing which policy is to be applied. Now, here.
So, according to you, it's not the date of issuance of the certificate?
I'll not say not according to me, because the Coal India stand was totally different.
Yes.
Coal India stand
according
was,
to the decision.
According to the decision, the starting point for consideration of the application of the 2000 or 2006 policy is not the date of passing.
FMCC.
Is not the date of passing FMCC, but when the FMCC process had started with the written examination, started by the written examination.
So, according to you or the judgment, the starting point is the date of holding the written examination.
For FMCC.
For FMCC.
FMCC, yes. FMCC, my lord, there is a provision for holding written examination. My lord, in the promotion process, there is none.
No. It's FMCC.
Therefore, FMCC written examination, that is the date which is to be applied. Sorry, that is the which is to provide the basis for applying either
old or the
new policy, old or new policy. That is, my lord, the judgment of the division bench. That is the reason why the Coal India lost in the previous litigations, because its policy which says that the rate of passing, that was not accepted by the division bench, by the Supreme Court. It was not accepted. The starting point is the initiation of the selection process for FMCC. Now, applying that, Coal India had to grant, antedate certain promotions. Antedating certain promotions based on this. Because why? Because in 2002, when the writ petitioners here had succeeded in passing the FMCC, they were moved vertically to E3 in the first class channel. But in respect of the respondents who obtained FMCC not in E3, not in E2, but in E3, but in E3, and their date of passing FMCC was post 2006 December, February, 12th June 2006. They were not given the benefit of 2000 policy, but were guided by the 2006 policy that is only vertical, only lateral, only
Horizontal.
horizontal movement to the first class channel. They did not get the benefit of 2000 policy of vertical promotion. Therefore, they felt aggrieved. They felt aggrieved and they filed the case saying that our selection process must be taken to have commenced with effect from the date of holding the examination for FMCC. That's the specific case of the petitioners. I shall show
In
that.
the earlier matter.
In the earlier matter. That was a specific case of the petitioner. And that was finally upheld. That as I said, the single bench judgment, there is some controversy. I shall point out. But in the division bench as well as the Supreme Court specifically held that this is to be from the date the process had started, selection process, and which is the date of holding the examination, the written examination. That is not the entire case. Now, based on this, the respondents were given promotion antedating the ones they had earlier obtained. This antedating, my lord, was the consequence of these judgments.
Yes.
And therefore, my lord, one cannot raise a plea when I follow a decision passed by the Honorable Supreme Court. I have acted, my lord, strictly in terms of the decision passed by the Honorable Supreme Court. And if somebody gets aggrieved by that, that's not my fault. My lord, it is the Supreme Court which said that.
According to you, otherwise you will be in contempt.
Yes, otherwise exactly. I will be in contempt. Therefore, my lord, the Supreme Court may not thought it fit to decide the matter in respect of the parties before it. Because possibly it was felt, as I now submit, that the other groups are already beneficiaries of the 2000 policy. They are already beneficiaries of 2000 policy. The present group who had approached the court in the earlier matter, they were deprived of that benefit.
Though the selection process started prior.
And that is why they were deprived of this benefit. It is not that the court is conferring some benefit upon them. The court is curing the deprivation. The right which others got, like the present petitioners, of lateral promotion under 2000 policy was denied to the group which who are petitioners in the earlier matter.
Only one without interrupting. What was the earlier policy?
Earlier?
What was the earlier policy?
Earlier policy was that
do you have
when
copy of that policy?
Page 29 of the writ petition.
Of the writ petition.
Earlier policy is, my lord, the date of pass in respect of certain groups. E2 kindly take this. This was
Page
date
29.
29.
The 9 is not a legible.
But Lordship may straightway come to 33. That is
33. Yes, yes. 33 is the tight part, sir.
But it's also in the report.
Show me that portion where from which date.
It's also in the report. Please come to.
Also in the report.
Yes.
They have annexed this policy.
Yes.
Yes,
Page 15 of the report.
Page
15 of the report. At page 17, probably that is the policy which they were.
From the effective date of first class as mentioned under the certificate issued by DGMS.
Clause 4.
you acquired in E3. Those who pass while working second class stream in E3 grade should be promoted to E4 grade with immediate effect. Their seniority in E4 grade after should be determined on the basis of the formula suggested above for fixing seniority. So on a reading of Mr. Gupta, on a reading of 1 and 2 at page 17.
Yes.
Is it not that the petitioners, having passed the FMCC earlier while they were in E2 and were vertically promoted, a conjoint reading of 1 and 2, does it not suppose that they will be senior?
Yes, exactly, yes. I'm not on seniority. They will be getting the benefit of vertical promotion.
Yes.
Now, once they get a promotion at an earlier date, they are entitled to
Seniority affects, Mr. Gupta. After all, you have to decide on the seniority.
Yes, I'm coming to that. Once they are in a particular cadre at an earlier date, they become senior in that grade.
Yes.
No question about that. But supposing somebody was wrongly deprived of similar benefit, then he will be
he also will be given vertical.
He also will be given.
So in now petitioners moved from E2 to E3 by way of vertical promotion. And the private respondents are entitled to, as per the decision, to move from E3 to E4.
Yes.
Now the question is, when the petitioners moved from E3, because from E3 to E4, so far as the petitioners are concerned, that is ordinary promotion with regard to that years of service in that grade. So when the petitioners move to E4 by way of normal promotion, and when you are entitled to vertical promotion from E3 to E4 by virtue of FMCC. So if they move to E4 earlier, can you bring them below the private respondents if they are FMCC, even by giving them vertical promotion is on a date subsequent to their moving to E4? Two things. From E2 to E3, they have got vertical.
I have followed, Milord, but I am not straightway.
Because these dates may be relevant. Mr. Mojumdar, have you got those dates from E2 to E3? From E3, I think from that chart it will be evident.
Yes, yes. That's
that
page,
chart.
Page 34 of the report.
Yes. So if we, from that, you have to prepare a chart when they got this FMCC, the date, because that will be the date when they were entitled to vertical promotion from E3 to E4.
No, Milord. Our case of vertical.
Yes, vertical, not horizontal.
Will be on the basis of an order.
Yes.
Not the actual date of passing. On the basis of an order,
order
which antedating was done.
What is the order? Order, according to you, the ratio of the judgment is that those persons in respect of whom, according to the judgment, the written examination for FMCC was held prior to 12th of June 2006, they will be entitled to a vertical promotion. Let us accept that position, that the private respondents were...
The question still remains as to whether that will affect promotions earlier given. Persons who had earlier qualified in FMCC, whether they will retain their high seniority or not. That's the issue.
Yes, because if these petitioners moved to E4 on a date prior to the obtaining of FMCC by the private respondents. So in E4, they were senior. They were born in the cadre on a date prior to the private respondents could have been granted vertical promotion.
Possibly that's not the situation, but I shall apprise your lordships of that. Otherwise, this could not have been done like this, because this is not, my lord, the only instance where some persons are getting affected like this. The entire list was considered.
Yes, yes.
And on the basis of
So if this is clarified, the entire thing may be clarified on the basis of, because the fact is from which date. So you have to, while refixing, you must have followed a procedure. So the ratio of the judgment is that, let us assume that these private respondents are entitled to the benefit of vertical promotion. So from E3, they were on E3, all these private respondents passed FMCC while on E3. But from which date they can be vertically promoted? That has to be on the date of issuance of the certificate. That page 17 of your report, conjoined reading of subclause 1 and subclause 2. So if that is so, if Mr. Majumdar's clients were promoted to grade 4 normally prior to the date of issuance of FMCC, can you bring them?
No, certainly not.
Only
I'm
one not
thing,
containing that E4, there may be one difficulty in this year, because in the meantime, that E4 got redesignated as E5 in 2010.
Let us not, we need not go into that redesignation. Let us go to that earlier one. Have you checked, Mr. Majumdar, what's the fact? Their FMCC certificate is on a date after you were promoted to E4.
Just kindly give me only 1 minute still.
You can verify that. Let me hear Mr. Gupta in the meantime. Yes.
So that is the only thing, that needs to be produced before it. So the judgments that have been cited, born in the cadre, etc., everything, will not be relevant. Once I can establish before your lordships that their rights had not been affected at all.
Yes.
If I can prove that, then all
their rights will be affected if
if
they were
earlier promoted.
Yes, they were promoted, because I think this matter boils down to that. If normal promotion for the petitioners were on a date prior to FMCC of the private respondents, their seniority could not have, they have to be placed at a position senior to that of the private respondents.
But that will not be the
No,
situation.
probably not, if I have understood your lordship's query correctly. By way of an example, if your lordship takes 2 pages side by side from the report filed by Coal India, page 24 and 33 side by side.
24 and
33.
Mr. Gupta can also verify that. That 24 and 33, yes.
Of the report.
Of the
report of Coal India Limited.
Yes, let me check up. Yes, report, yes.
Please take the first entry at page 24. Madhusudan Singh, he is the first petitioner.
Yes.
But he became E3 by vertical promotion on 13th August.
Yes.
Because of that obtention of first class certificate.
Yes.
He became E4 on 15th February 2010.
Yes. And what is the date of first class certificate of?
No, he became E3 to E4 on 13th August 2004. E2 28th August 2002.
Yes.
E3 to E4 13th August 2004.
No, you passed
in E2.
In E2. So you have to be vertically promoted from E2 to E3. Where is that date? On 13th of August. Yes, you have been vertically promoted. This is the date of
E3 to E4, 13th August 2004.
How can it be? Because you will be promoted from E2 to E3 on 13th of August. You got vertical promotion.
Part of the revised rating.
Oh, this is the revised one. What was the original?
It should be 2, 3, not 3.
Yes, this Mr. Majumdar is after revision. We have to see the earlier one. You can check up that 2010 order, I think. That's what we are showing. I think Mr. Gupta and Mr. Mojumdar, I think this chart showing what is the petitioners and the private respondents were in which cadre while they passed FMCC. According to Mr. Mojumdar, I think that is an admitted position that the petitioners passed FMCC while they were in E2. So the date of FMCC certificate, on that date they will be moved vertically to E3. So that date is relevant from E2 to A3 and from E3 to E4, normal promotion.
On
That
on what date?
what is the date when they got that promotion? With this, we have to see what are the relevant dates of FMCC, because all of them, private respondents, they were on E3. Only the date of the certificate, that will be the relevant date for giving them vertical promotion from E3 to E4.
Not the certificate date, but the examination.
No. Examination is according to you which date of examination, which policy. But effect is, kindly come to page 17. Circular says, so policy, yes, old policy. But the old policy says effect is date of certificate. Kindly come to page 17.
Kindly take the Supreme Court judge. Our policy is not accepted by the Supreme Court.
Mr. Gupta, correct me if I am wrong. Two things. One is which policy to be adopted.
Yes.
Old or new. Accepting your argument as per the Supreme Court judgment, yes, in case of the private respondents, the old policy is to be accepted. No difficulty on that. Now let us come to what was the old policy. Kindly come to page 17.
17.
Of your report. There you have annexed the old policy. So now this policy is to be followed. Old policy is to be followed. What does the old policy say? Number one, those who pass first class mining manager certificate of competency while working in E2 grade should be placed in E3 in first class stream, not mainstream, from the effective date of first class as mentioned under the certificate issued by DCMS. So the date of certificate with effect from that date. Such of the executives who pass the first class while serving in E2, that is according to the petitioner's case, promoted to E3 in second class channel, that is the other thing, second class channel, that is ordinary promotion. Promoted to E3 in second class channel and subsequently horizontally moved to E3 grade in first class will also be placed in E4 if their contemporaries or juniors passing in class E3 grade have been placed in E4. Those who pass first class while working in second class stream in E3, that is the private respondents, should be promoted to E4 with immediate effect. The seniority in E4 grade after promotion should be determined on the basis of the formula as suggested above for fixing seniority of E5. That is seniority for the next grade. So what does clause 1 and 2 mean? This policy is to be given effect to.
Yes.
So this policy says the effective date is the date of certificate. So if the petitioners move to E4 on a date prior to the issuance of certificate, so the private respondents could not have been placed in E4 on a date prior to the petitioners.
Possibly that is the position, because if that page 24 chart is the redesignated nomenclature or the revised nomenclature, then this we were promoted to E5, that is E4, unrevised E4 in 2010.
Yes, in 2010. And their certificate is of 2006.
6 and 7.
So earlier.
That's right, in E3 grade.
So they are senior. Then,
No, that I'll show you now.
then they will be senior.
Come back to your lordship with proper fact on this aspect only.
Yes, because this is the issue. But your reasoned order has not taken into consideration anything.
That's not a reasoned order as required to be passed.
But a representation was given.
There is a representation.
So that was
we have only implemented Supreme Court judgment.
Was it not expected that when a representation was given? This is the issue. How only says we have given effect to that. How have you given effect to that? That is the thing which is to be.
The effect has been given in this manner. Those who had participated in the written test prior to 12th June.
Yes.
For them, the vertical promotion has been given.
Yes, accepted.
Yes, that is only a thing.
That is not disputed. I think Mr. Majumdar is also not disputing that. They will be entitled to vertical. But where they will be placed, there lies the difficulty. He says these private respondents cannot be placed above him. He is not against placing the private respondents to E4.
That may depend on date of promotion to E4.
Yes.
For them.
That is according to my understanding. If their ordinary promotion to E4 is on a date prior to the FMCC certificate, because certificate date is the relevant for the date when they will be granted vertical promotion.
But subsequent promotions do not depend on the date of promotion or
no, but first.
First.
Thereafter automatic.
Thereafter, promotion dates of promotion may change.
Yes.
Therefore, even because the Supreme Court.
No, the only thing is from E3 to E4.
Supreme Court judgment was implemented at a point of time when it was in E5 situation, perhaps. Therefore,
but from E4.
E4.
But you have
E5.
changed, refixed from entire thing.
Yes.
At E5, but you have changed it from.
I had to, because.
Yes. So you have refixed it from an earlier point of time. So that change is from E3 to E4.
No, the promotion order which is impugned is refixation of seniority in E5 grade.
Exactly.
Yes.
E5.
Not in E4 or E3.
Only in E5.
Only in E5.
E5 is E4. Previous E4.
Previous E4. Let us say
yes.
previous E4.
Previous E4.
Yes.
So that is the from E3 to E4. That is the point of difference.
Now, if that be then the second difficulty which may arise is, if this is given a retrospective effect, then in the meantime, say I got promoted to E3 in 2003.
Mr. Majumdar, is it not better that you make a comprehensive representation? Let them pass a detailed order on this.
But I made this.
No. Yes, but the rights of several others may be also hard. That is the difficulty.
As a matter of fact,
it's not that the court not deciding this issue, because this issue or these points were not considered.
Not at all. Not the difficulty
I think
arose.
Mr. Gupta will not also support that all these points were considered and it has been reflected in the order which is under challenge.
The difficulty would not have arisen probably if Coal India Limited would
because
have.
This whole exercise of fact-finding exercise has to be done.
Then what comes the question of point-to-point determination of seniority,
yes.
person to person.
So can it be done by the court?
No,
or
the
it is
court can only lay down the guideline.
Guideline is that if they pass the old policy, that is the judgment is there.
Now
they have to give effect to that.
So they are giving it
according to them. They have given effect to this.
Now 2003 to 2006, petitioners were promoted.
And now this fact is on what was the date of these writ petitioners ordinary promotion?
Right.
What was the date? all these are the factual exercise which has to be
Say
undertaken by the.
petition number, say for example, petition number 1 was promoted to E3 in 2003.
Yes.
He would have been normally promoted to E4 in 2006. Maybe on a date prior to the date of obtention of first
It will
class
depend
certificate.
from one person to another. So entire fact finding exercise.
Direct them to do that. But principally, two issues, this will torment the court time and again. One is.
Gupta, can a direction be passed to revisit your decision?
That your lordship can always do, my lord. I cannot stand in.
Because the entire fact finding, otherwise, not a issue of deciding.
Because by reason of this judgment, my lord, not only these 31
No,
petitions,
you have
but
to consider
several
that.
others.
Yes, that is there according to you, that these private respondents will be entitled to a vertical promotion. I think Mr. Mujumdar is also not disputing
No,
that.
all I am submitting is
the question of seniority.
Right. All I am submitting is this, my lord.
And interpretation of this page 17, 1 and 2. What will be the effect of this?
By
This the authorities have not decided.
Perhaps they have decided, otherwise they could not have passed this order fixing
No, in the
particular dates.
impugned order, it has not been said anything.
No, not in the. I mean the order by which the judgment of the court was implemented.
Judgment of
the court was implemented. Judgment of the court was implemented with regard to not only these 31.
Yes, you have implemented.
Implement with regard to many.
Yes, with regard to many.
Yes.
According to you, while giving effect to the judgment, some others who are not parties in the in those matters were entitled to some benefit. You have given them benefit. Now they have pointed out some anomaly. According to them, their seniority could not have been affected as a result of this. They are placing this, and you have to consider this page 17, point number 1 and 2. The order, they have made a representation.
Take page 36 of the report. No, sorry, affidavit in opposition.
Of the affidavit in opposition.
Page
Yes.
36. The judgment. Single judge.
Yes.
Last sentence, my lord, at page 36.
Yes.
State authorities are directed to promote the writ petitioners to E4 grade from E3 grade in the first class channel with effect from the date.
There's no difficulty on that.
No, kindly see.
Yes.
By treating them at par with 2003, 4 and 5 batches.
Yes.
Treating them at par with this batch.
At par means they will be entitled to vertical promotion. They were entitled to vertical promotion, 2003, 4 and 5 batch. They will be entitled to vertical promotion.
Vertical promotion was also available to 2001, 2002.
Yes, yes. But I think
3, 4, 5.
3, 4, 5. So this is with regard to vertical promotion, accepting that. Now, while giving that, whether you can affect their seniority, because by giving promotion, you are preparing a gradation list where the petitioners.
I have followed, but that has to be found out from the records.
Yes, and while giving that promotion, how have you implemented these 1 and 2 of page 17?
Particularly 2, perhaps.
1 and 2, because 2 says this, but seniority says the formula as per 1.
As per 1, but in 1, E5 doesn't find place, perhaps.
Yes, so the formula has been specified in 1. That formula has to be applied in this case.
Similar formula 1.
Yes.
Their Miller formula for fixing seniority of E5 perhaps doesn't find place, although 2 says so.
Just clarify this aspect. What does 1 and 2 say? What is the effect of this and how it has been implemented? I think if you give them a hearing, they can clarify. That will be the end of the matter. I can direct them to submit a comprehensive representation. I think that will be better. Both of you can consider that this, because what is the effect of these 2?
The other point would be, my lord, what is the, now, my lord, after 12 years, we come to know that we are junior. in 2015, from 2003 to 2015, after
That
12
means,
years.
Mr. Majumdar, that the authorities can take care.
Right.
If the authorities find no, your seniority has been adversely affected, you are entitled to, you have to be placed above these private respondents. They have to take consequential steps therefrom.
In effect, there has to be a man-to-man exercise undertaken by the authorities.
Yes,
Because
so it's entirely fact finding.
two
Some
grounds.
of the petitioners may be entitled to, all may not be entitled to. Some of the private respondents, their seniority may have been rightly fixed, others may not have been.
May not be solely.
It's entirely fact finding.
Also on the ground of, say, not on the expiry of 3 years service, one is entitled to an automatic promotion.
So
all these things have to be redone.
And there may be some others who are not before the court.
There are.
Maybe some others.
At least 50
So
others.
by passing some direction, what you have said, that by giving effect to that, your rights have been affected. Some orders passed, maybe others' rights may also have been. So the authorities are in the best position, all will be before them.
Kindly fix a time period for this, until such time no further effect to be given to this E7 grade. E7 list at
I'm
least.
keeping it under this. Come, both of you, if you both of you agree to, I will be passing that order. I think
উঠে যাচ্ছে কালকে তো বসবেই ও না তুমি থাকো না তাহলে বুধবার করে দিন
Mr. Gupta, if you have anything, if you have something to clarify on 1 and 2, you can also. For that, I am keeping this.
I'll not be in a position to clarify that. In the background of the, in the background,
you have the benefit of consulting the persons who have done this exercise. That is why.
For only interpretation of 1 and 2 will not do.
Because Mr. Gupta, if you are satisfied, if you can justify this, no use unnecessarily sending them to, again sending them. It will be a wastage of time. Clarification, and if you say yes, no, it has not been done, it can be
probably
said.
because there are judgments of the court, not where the court Colinda Limited itself said that it should be from the effective date of passing.
But Mr. Majumdar, here in this matter, according to Mr. Gupta,
no interpretation of this circular.
Their stand has not been accepted.
Yes.
The judgment now has to be given effect to.
The judgment says give effect from the date on which they passed, ultimately.
Yes. But according
apply the policy.
There are two aspects. One, you say that the private respondents are not entitled to the old policy.
Correct.
That is one part.
So vertical promotion. So what is the
Not
effective
entitled
date?
to that, according to you. If Mr. Gupta says no, they are entitled to as per the old policy. So that is one. Even if Mr. Gupta's submission is accepted, now the question comes: if you have promoted earlier in E4 and their FMCC
Can that seniority be affected? That's
so there are two folds
Lord,
of submission.
give me a week's time. I need to see it.
Both of you, and also Mr. Majumdar, you also consider this aspect because Mr. Majumdar, Mr. Gupta says that they are entitled to this old policy.
Old policy.
Yes. Because as per the division bench and the Supreme Court judge, kindly make submissions on that. And if both of you agree the entire matter to be relegated, no problem on that.
On this, all three judgments speak in same language.
Let Mr. Majumdar also consider that.
All three judgments on this.
Mr. Majumdar Lanet, advocate appearing for the petitioner, concludes his argument. Mr. Gupta Lanet, senior counsel appearing for Coal India Limited, commences his argument but could not conclude due to paucity of time. Mr. List this as paid for by Mr. Gupta, list this matter. Thursday, will it be possible, Mr. Gupta? No. This Thursday?
That's only. Kindly give me a week's time.
14th.
14th is possibly the last date on which your lordship is sure to sit singly.
Kindly make it 12th.
Other dates may, Thursday may be a suitable day. 14th, you are in difficulty.
I have no difficulty.
Can I fix it on 14th? Tentatively, all dates are.
That will be a lordship. Possibly that.
Don't hear to all those comments of Mr. Majumdar.
No, we go by the list instruction.
So, কি হলো?
হ্যাঁ লিস্টে তো তাই আছে
on November 14, 2024 under the heading আছে? Under the heading continuing matter করে উপরে under the heading continuing matter এর যে হেড আছে সেখানে করে দেবেন। It will appear under the heading continuing matter. Mr. Majumdar. আচ্ছা এই এইগুলো নোটটা এটার সঙ্গে ট্যাগ করে দিচ্ছি। ভেতরে কাজ করবি এই জাজমেন্ট গুলো আর ওইটা একসঙ্গে করে রেখে দিবি।
Avoiding the expression part.
Yes.
Avoiding the expression part. Continue.
Yes. Yes, Mr. Jana. Where is your other side?
I have,
Left.
I have informed the, well, Kali fixed the matter there tomorrow.
Not today.
Tomorrow, let it be placed in continuing matter. Because the my lord's judgment is covered by you.
Tomorrow it will be taken up.
Okay, so.